everybody. I'd like to call this meeting to order. Welcome to meeting number 28 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order of reference of February 2nd, 2026, the committee is meeting to continue its clause-by-clause study of Bill C-16, an act to amend certain acts in relation to criminal and correctional matters, child protection, gender-based violence delays, and other measures. Today's meeting is taking place in hybrid format pursuant to the standing orders. Members are attending in person in the room and remotely using the Zoom application. I'd like to confirm that sound tests were done. Andrew, you're good? Okay, thank you. I'd like to make a few comments for the benefit of witnesses and members. Please wait until I recognize you by name before speaking. For those participating by video conference, click on the microphone icon to activate your mic. Please mute yourself when you're not speaking. For those on Zoom, at the bottom of your screen, you can select the appropriate channel for interpretation, either Floor, English, or French. For those in the room, you can use the earpiece and select the desired channel. A reminder that all comments should be addressed through the chair. For members on Zoom, for members in the room, if you wish to speak, please raise your hand. For members on Zoom, please use the raise hand function. The clerk and I will manage the speaking order as best we can, and we appreciate your patience and understanding in this regard. Welcome to our witnesses. Welcome back to our witnesses. They're here to answer technical questions you may have. From the Department of Justice, we have Mr. Matthew Taylor, Senior General Counsel, Director General, Criminal Law Section. And we have Natalie Leveman, Senior Counsel, Criminal Law Policy Section. And we also have Mr. Michael Ellison, who is the Counsel, Criminal Law Policy Section. So thank you all for being here. We've got a long day scheduled ahead. If anybody needs a break, just give me the look. Happy to suspend for a few moments to accommodate people. We left off having just completed NDP 11, which carried. So we are now on G15. So I will start by saying, shall G15 carry? Yes. Carried. Shall clause 32 carry? Carried. Shall clause 33 carry? Yes. Carried. Okay, which takes us to clause 34, and we will start with NDP 12, and I will start by welcoming Ms. Kwan and turn the floor over to you.
Thank you very much, Mr. Chair. I'm standing in for my colleague Leah Gazan, who was here previously, to put some comments on these amendments. So on NDP 12, the amendment would change the bill such that the accused must make an application for production where possible to the judge before whom the accused is to be or is being tried, so that having the same judge is not mandatory. Legal experts have shared with us that this requirement may not be realistic in all jurisdictions given different capacities and resources and could lead to unnecessary stays. So that's the motivation behind this amendment, Mr. Chair.
Thank you. Mr. Brock?
Thank you, Chair. Well, I don't disagree in principle. I'm wondering if it's redundant, and I'm going to turn to the officials on this issue. My understanding has always been that any reference to a justice also includes provincial court judges. It also includes Superior Court or Court of King's Bench or I guess Supreme Court in British Columbia. Is my interpretation, decades worth of work in the legal field, is that the application that's already within the code itself? And would this amendment be redundant in the circumstances?
So, thank you, Chair. Thank the member for the question. Currently, and since the O'Connor decision that first laid out the groundwork for these types of production applications, guidance from the Supreme Court of Canada has stated that it is highly desirable for the trial judge to be the one to hear this type of application, and that's something over the past 31 years or so, hopefully I have my math correct, that jurisdictions across the country have strived to achieve and to ensure that the trial judge is the one hearing it. And there are a couple of reasons outlined in O'Connor for that, mostly to ensure consistency between decisions and to ensure that these are heard at the appropriate time in the process. So In terms of redundancy, what I would speak to here is that with respect to NDP 12, really here, the main concern would be that if there's an expansion beyond the trial judge hearing these types of applications, then we could open up the door for more possibility of inconsistent decisions. For example, if a justice of the peace, who is also considered a justice, were to make an order for production at a bail hearing, and months down the line the trial judge hears or has the evidence before them and they disagree with that assessment.
Thank you for that, but the amendment NDP 12 does not speak specifically to a trial judge. It makes reference to a provincial court judge. So on the surface of this, I thought it was redundant because the use of judge includes both levels. But to be specific to your point, Mr. Ellison, do you think that there's value then in offering up a friendly amendment to the NDP to make reference to a trial judge as opposed to a provincial court judge?
Thank you for the question, Mr. Chair. My response to that would be that I think while friendly, and the intention would be friendly there, it would actually introduce redundancy at that point because we're already very clear in the criminal code, and Bill 616 would carry over the requirement that a trial judge hears this type of application. So at that point, if we were to do that clarity, we would simply be reconfirming the state of the law.
Thank you.
Mr. Housefather?
So that I can I just want to understand, because I understand it the same way Mr. Brock does. Were this to be limited to a trial judge, then it becomes redundant. The issue here is there's an expansion to potentially pre-trial judges with very limited evidentiary hearing, evidentiary basis, where then it's not. What I would then understand is the accused could then seek victims' private information at an earlier stage from somebody that doesn't even have the evidentiary basis to determine that. So I think there may be some inadvertent reason, or inadvertent way of drafting that has actually created a privacy issue for the victim in this actual amendment. Would I be right in that?
So, and thank you for the question, Mr. Chair, to the member. So yes, I would agree with this, that currently the restriction here is very intentional to ensure that we are better protecting the dignity and privacy interests of a complainant, and that access is not granted too early on a more limited evidentiary record. So there's a very well-intentioned amendment here, I imagine, which is to expand this, because there are times, especially in remote and northern communities, where it is difficult to get that trial judge assigned, but jurisdictions across the country have found workarounds. They have appropriate workarounds to ensure that trial judges can be assigned earlier in some cases to make these rulings.
All right, thank you. Okay, shall NDP 12 carry? No. Defeated. Okay, so G16. Ms. Latanzio.
Doing this, Mr. Chair. So this is once again a technical amendment. This motion would expand the application of the regime governing the production of private and therapeutic records in possession of a third party in sexual offences, trials to cases involving an offence under any act of Parliament that is of sexual nature or committed to a sexual purpose, and not to just a criminal code offence that is of a sexual nature or committed for sexual purpose.
Thank you. Shall G16 carry?
Yes.
Carried. Oh, sorry, Mr. Brock. Go ahead.
I need some clarification to the officials. The expansion to all acts of Parliament, in your view, is this designed to capture these types of applications perhaps in the military context? To give one example as to the expansion?
Mr. Chair. So the intent here is really to capture, my colleague, Ms. Levman, on the previous date had mentioned on G8, which is a very similar amendment to the sexual history regime, that this would clarify that this also applies to other federal statutes, in particular the Immigration and Refugee Protection Act. So for the trafficking and smuggling offenses that are contained within that act, to ensure that when they are committed for a sexual purpose, that these protections apply there as well. I'll allow my colleagues later on to speak to the National Defense Act, but there are also amendments in C16 that would apply these principles within the National Defense Act as well.
G16 carry? Yes. Carried. G17.
Mr. Chair. So this motion would clarify that victims or witnesses who are protected by automatic publication bans that can apply to hearings to determine the admissibility or production of highly sensitive evidence in sexual offense trials may disclose information about the hearing, including to a legal professional, healthcare professional, or a person in relationship of trust with them, provided that they do not intentionally or recklessly reveal the identity of any other person protected by the publication ban.
Mr. Barber?
Tanzio, does that include the recipient? When you say they, you mean the recipient of the information, right?
Good, okay. All right, shall G17 carry? Yes. Carried. G18.
Once again, this amendment is a technical one and for the same reasoning that I mentioned earlier in C16.
Yes, I think we all understood, yeah. Thank you. Okay, all right, so G18 carry?
Yes.
Okay, carried. Okay, G19.
Once again, Mr. Chair, it's Wade. You, Marilyn, go ahead.
Yes, this is another technical amendment. It changes the English language portion to saying that the prosecutor may produce the listed records rather than disclose them, as was in there. So it's just a linguistic change.
Thank you. I see no hands. Shall G19 carry? Yes. Carried. NDP 13, Ms. Kwan.
Thank you, Mr. Chair. As with the previous NDP amendments, that this one would ensure that the complainant has the right to independent legal advice, ensuring that this bill would truly uphold victims' rights and does not leave them without protections in the court proceedings.
Thank you. Anybody else?
We're contemplating a scenario here where the complaining witness would obtain counsel. The alleged victim, that is? To the mover of the motion.
It's a joint application.
Just a quick question to the officials. In theory, I don't object to this, but it's highly unusual to insist on the complainant being represented in criminal context. Am I correct?
Yes, and thank you, Mr. Chair, to the member. Yeah, so there are very specific circumstances within the sexual history regime and the private records regimes where a complainant has limited forms of standing. In this case, this would be an amendment to a portion of Bill C-16 that replaces what we call the explicit waiver provision that's currently in the production regime. So when the Crown is in possession of private records, currently under the law, they can produce those records if the complainant waives the application of those protections, essentially. And then the court will consider admissibility later. Bill C-16 proposes to reduce delays by changing the explicit waiver power to the new authority to produce power that is in the bill. And that was just amended, that language from disclose to produce. So this is the power of the Crown to produce documents to the defense that are in their possession. Now, this amendment here would require that before the complainant can give their permission for certain records to be disclosed to the accused, that they would first have to have the opportunity to obtain counsel. So that would be, it would be a step up from the current existing law, where currently just waiver is required. This would actually require counsel first, and it would, in theory, lead to potentially further delays as a complainant would have to first hire a lawyer, get their advice, and then go back to the Crown and say yes or no, or whether they can produce. So the intent of the amendment here would be a different balancing of victims' rights versus efficiency.
Just quick follow-up. How does the waiver slash consent regime being contemplated here, how's that balanced against the Crown's duty to produce?
Yes, so the Crown has its general duty to disclose. That comes out of the older cases of Stinchcombe, and of course, as you know, and that duty to disclose generally the fruits of the investigation to the accused person, that is tempered and restricted by the private records regime. So the private records regime says if you have this category of records, even if it's part of the investigation, you must hold off, you must notify, and then an application must be made so that we can ensure these protections are in place. And the explicit waiver provision right now that is in existence in the code allows for you to override that and produce those documents just for disclosure to the defense at this time.
I don't know. I don't want to make a mistake here. I understand the intent of the NDP amendment. I am concerned, however, that the intent of the bill is to try and move proceedings along to avoid Jordan dismissals. I am a little concerned that we may be holding up proceedings to actually deviate from the intent of the bill. I don't know. I see Mr. Housefather nodding, but I'm not sure where the Liberals are at on this amendment. This is a friendly conversation, like not political. Any thoughts?
I think you'll find out their intentions when they vote, Mr. Baber. But are you finished, Mr. Baber?
Yeah.
Okay. Mr. Housefather?
I was just to say, I agree with what Mr. Weber said.
Okay, all right. Okay, shall NDP 13 carry? No. Defeated. NDP 14, Ms. Kwan.
Oops. Thank you, Mr. Chair. So once again, this will ensure that input and consent from the complainant must be considered before their records are disclosed in legal proceedings. So many of these amendments is in the interest of the victims, which I think is an important component. And while I understand there's a need to expedite, but at the same time, protecting the victim's rights is critical as well.
Thank you. Mr. Brock?
Yes. To the officials, what is the nature of communications that's contemplated by this amendment?
Yes, so this was discussed, and thank you for the question. This was discussed in the case of the King and JJ. This is an issue that has occupied a lot of time in court. But when it comes to communications, what we're primarily looking at here are electronic communications that are slowing down court proceedings. So a Crown could theoretically receive from them, from the police of jurisdiction, thousands of text messages, for example, in a human trafficking investigation between a complainant and an accused person. And before those thousands of messages can be disclosed to the accused, assuming they're going to be used to prove the case, it actually not only has to go through the Crown vetting procedure and them exercising their duties to protect a victim through properly vetting disclosure, but it also has to go through the entire production regime. So this has been one sticking point in particular in especially human trafficking cases, but sexual assault and related cases as well that get more and more complex when we have large volumes of communications. So communications have been singled out as something where we can clearly save time and we can allow the Crown to exercise its responsibilities as a Minister of Justice to properly and fulfill its disclosure obligations to protect the victim, get those records to the accused that are going to be used at trial in any event because the Crown will lead them, give them the time to do that, and we don't necessarily then have to wait all the way until we have a trial judge to make a decision on production. And then at that point, defense would understandably be upset that trial is very close and they suddenly have thousands of communications. So we're primarily talking about electronic communications.
But you used as an example human trafficking. I'm looking at this through the lens of an IPV case, particularly in the context of a marital union, which would be protected. Communications between a married couple, if one is the accused and one is the complainant, would be protected, and this would not apply to that, correct?
So the Crown would have to, it's an excellent fact scenario that you've pointed out. The Crown would have to, in this situation, this is not a the proposal here around giving the Crown the ability to produce these types of documents and replacing that explicit waiver provision, this is not mandatory for the Crown to do. The Crown still has its responsibilities to only disclose things in a proper manner. For example, making appropriate redactions and not disclosing things that might otherwise be protected to, let's say, a third-party accused on the same case, a co-accused. So in that example, a Crown does have the authority here to, if this were to pass, to disclose communications. However, if there is a co-accused and there is some sort of special consideration there, not part of this, the marriage, obviously, and they have concerns there, they can still withhold that disclosure, as they would be expected to today if there was a concern, or make appropriate redaction. So I just want to stress that these powers are discretionary. It's an exercise of Crown discretion as it's drafted, and nothing here compels the Crown to make production. It is simply their decision within their role as a Minister of Justice.
Will this amendment assist Crown prosecutors in the carriage of their responsibility, yes or no?
Yes, it would.
Thank you.
Mr. Ellison, thank you for your excellent testimony and assistance to all of us. The spousal complaining witness is not a compellable witness. I think that's the state of law. You can't compel. In other words, they're still capable of some of their own decisions. But on the NDP amendment, essentially the amendment is that the disclosure would be conditional on the complainant's agreement. That's the operative provision of this amendment, correct?
Yes. So the crux of this amendment here would be to constrain Crown discretion that Bill C-16 proposes to provide, and in that case, no, I just wanted to make sure that I didn't interrupt you.
I'm sorry, please continue.
No, of course. So the crux of this amendment would be to constrain the Crown discretion that Bill C-16 proposes to provide. So right now, Bill C-16 says we know our Crown attorneys are educated, they know their role as a Minister of Justice, and they can make the appropriate determinations. And especially when it comes to communication evidence, which in certain cases can be vast, they want to be able to exercise that discretion, make the appropriate redactions, get that disclosed to defense so that they don't have to wait until the 11th hour right before trial when they get that trial judge assigned in order to get a production order.
Thank you, Mr. Ellison. Just one sec. Can I just understand from you, how do you balance this requirement of consent by the complainant proposed by the NDP amendment versus the Stinchcombe requirement to disclose?
So I would say that we are working within the production regime, which already provides a constraint on the Crown's ability to disclose. So in this case, we already do have that constraint there. Parliament would be free to impose further constraints. It would go against the intention of Bill C-16 overall to provide greater discretion.
Thank you, Mr. Ellison.
NDP 14 carry. Defeated. G20. Ms. Latanzio.
Yes, Mr. Chair. Again, a technical amendment, same as G16, G18.
Thank you. Shall G20 carry? Yes. Carried. G21.
Mr. Chair, this is another technical amendment, so it corrects a typo which changes the intent of proposed section 278.29, paragraph 2, which governs the test for admissibility of records and therapeutic records, including when they contain sexual history evidence. This amendment would clarify that all therapeutic records, including those that contain sexual history evidence, are only admissible if they meet the, quote, innocence at stake test by removing the disruptive or from the list of records that are subject to the private records admissibility regime in sexual offense trials in paragraphs 278.29, paragraph 2A, 2C, and replacing it with the conjunctive, and thus clarifying that therapeutic records that contain sexual history evidence, which are listed in paragraph 278.29, subparagraph 2A, must also meet the innocence at stake test in paragraph 278.29, subparagraph 2C.
Just question, Mr. Chair, we're on 22 now? G22?
21.
Yes.
21.
That was 20,
That was,
we're on 21.
you were just describing 22.
I did 21. Did we not vote on 21?
No.
21 is the same as G16 and G18, Mr. Chair.
Okay.
Sorry about that.
That's quite okay.
I got ahead of
You got
myself.
ahead of yourself. I
No,
was like
no,
wondering,
we've
why are you
I
on
thought
the
we had
next
voted
amendment?
on that. Sorry about that.
Okay, so do you have any further submissions on 21 then?
None on 20. Those are all for 22. Sorry
Okay.
about that,
Shall
colleagues.
G21 carry? Yes. Okay, so I have a feeling Ms. Latanzio is going to speak to G22.
But she just did.
I
just
know,
did.
I know. And I have a feeling I know what she's going to say.
I thought you had asked for a vote. I apologize, Mr.
No, no,
Chair.
that's okay.
Mais oui, mais oui. J'ai dit l'amendement, c'est pas le même, ton
Désolé.
Sorry, says Mrs. Latancio.
G22. No. Shall G22 carry? Yes. Carried. G22.1. Ms. Cowd.
So G22.1 is a technical amendment. It corrects linguistics inconsistency to reflect policy intent of the legislation to protect victims and create deficiencies in sexual proceedings. The amendment, if passed, it would restore the existing procedure for service to the complainant at stage 2.
Thank you. Shall G22.1 carry?
Yes.
Carried. G23. Who's got that? Patricia.
3. Hold on a minute. Again, Mr. Chair, this is a technical amendment, as previously stated in G20.
Thank you. Shall G23 carry?
Yes.
Carried. NDP 15. Back to you, Ms. Kwan.
Thank you, Mr. Chair. NDP 15 is related to an earlier NDP amendment. This amendment provides complainants with a clear statutory right to counsel from the outset of the joint application process.
Thank you. Mr. Bauer?
I just want to assist my friend from the NDP. I wonder, Mr. Ellison, the complainant generally has the right to be represented by counsel. Does my friend try to allude to standing? Is that the issue here? In which case, maybe this amendment should be reconsidered?
So thank you for the question. This is essentially identical to NDP 11 within the context of the sexual history regime, which carried, I believe. And here, this is within the joint application procedure that's being proposed for admissibility of private and therapeutic or private records, not therapeutic records. And the department's position would be that the complainant does have standing and has the ability to be represented by counsel because it is a joint procedure where the Crown, defense, and the complainant must agree in order to take advantage of the procedure. So this would just simply clarify that the complainant has that right because, of course, it is relatively unusual for a complainant to have standing, but it is intended within the joint application procedure.
Thank you.
All right. Shall NDP 15 carry? Yes. Carried. G24. Ms. Latanzio.
Thank you, Mr. Chair. Again, the same technical amendment that was brought forward for G17.
Thank you. Shall G24 carry? Yes. Carried. Shall clause 34 as amended carry? Yes. Carried. Okay. Takes us to clause 35 and to proposed amendment G25.
Thank you, Mr. Chair. This amendment basically would ensure that the human trafficking provisions require considerations of 2 additional factors that we've just agreed to in previous amendments, which is related to the threatening to use violence against any animal known to the victim as opposed to just one owned by the victim, or damaging or threatening or attempting to damage the victim's property or the property of anyone known to them. So basically, it's 2 factors that we're adding that we had agreed to in previous amendments.
Okay, shall G25 carry? Yes. Carried. Shall clause 35 as amended carry? Carried. Shall clause 36 carry? Yes. Carried. Okay, so now we are into new clause 36.1. And the first proposed amendment is CPC 20, which I have reviewed and have deemed out of scope.
Challenge.
Okay. Mr. Clerk.
Very good. Thank you, Mr. Chair. On the question, shall the chair's ruling be sustained? Madame Latanzio?
Yes.
Monsieur Housefather?
Yes.
Mr. Chang? Yes. Monsieur Rana? Yes. Ms. Khalid?
Yes.
Ms. Gladu?
Yes.
Mr. Brock?
Well, it's really disappointing that
Yes or no,
this
Mr.
committee
Brock?
is not considering robbery with a
It's yes or
firearm
no,
a very
Mr. Brock?
serious offense. The answer is absolutely not.
Thank you.
Mr. Baber?
No.
Mr. Gill? No. Mr. Lawton?
Absolutely not.
Mr. Fortin? Seven.
Okay. Thank you. Okay, which takes us to CPC 21.
You're ruled out of order.
Oh, no, CPC, that was
Oh,
CPC 20.
Sorry, I thought it was
We're on
21.
CPC 21. Unless you want me to rule that one out.
Rule 21 out of order.
I'm not, that's why I'm asking you to speak to it.
Oh,
Yeah,
well, isn't that interesting?
caught you off guard
I
there, didn't I, Mr.
I
Brock?
shall definitely take the opportunity. Thank you, Mr. Chair.
21 is okay?
So 21, CPC 21 reflects on the ongoing, growing issue of extortion, which is spreading literally like wildfire across this country. We know that we have pockets of extreme activity in this country. Ontario is certainly not immune. Quebec is not immune. But ground zero, in my view, is the province of British Columbia. And I know that most of the members of this committee, if not all the members of this committee, at least from the government, some from the Conservative perspective, have actually toured various cities in British Columbia and heard directly from law enforcement, as well as provincial leaders, as well as municipal leaders, including the Mayor of Vancouver, the Mayor of Surrey, the Mayor of Abbotsford. I have taken the liberty of talking to victims of extortion, and it's absolutely heartbreaking to see the lawlessness that has been demonstrated by these nefarious actors, extorting with violence, quite often with violence, various sums of money. And it's rather disappointing that this Liberal government, a few years back in the 44th Parliament, collectively chose to vote down our Deputy Leader Tim Uppal's private members bill, which would have mandated mandatory minimum penalties for extortion. Now, that was a few years ago. The rising rates of extortion were not as extreme back then, but the crime itself is having devastating impacts to many, many residents across this country. And that was, in our view, the first Conservative attempt to undo the completely short-sightedness of this disastrous Liberal government in the 44th Parliament in choosing to put forward Bill C-5, which completely eliminated 14 serious mandatory minimum penalties in the criminal code. And for the likes of me, I have yet to hear any cogent, rational explanation from any member of the Liberal government, including attorneys general and prime ministers, as to why they saw fit to eliminate all mandatory minimum penalties for all the Controlled Drugs and Substances Act. This at a time when we have an opiate crisis in this country, where fentanyl is taking the lives of our loved ones, friends, and neighbors every single day of the year, where the RCMP are investigating massive fentanyl super labs in this country. One such super lab in the province of British Columbia, which had enough precursor to produce enough fentanyl to kill every single Canadian twice over. Yet this short-sighted Liberal government chose to eliminate mandatory minimum penalties for all drug offenses. So let's think about it. The rationale was, and this has not aged well, Mr. Chair, in terms of history, the rationale is we have to take active steps to address the over-incarceration rate of certain marginalized individuals in this country. We have to reflect the fact, which now, given Bill C-16, is an absolute failure by this Liberal government to acknowledge the elephant in the room, that there is a place in Canadian society for mandatory minimum penalties. When David Lametti, former Justice Minister and Attorney General of Canada, got on proudly his soapbox and said that they are ineffective, that study after study has showed that it does not have a deterrent impact on offenders, that there is a growing sentiment around the world in many democratic nations to remove mandatory minimum penalties. That was the position of the Liberal government. And now with C-16, we have the ability to bring back mandatory minimum penalties. So for all those reasons, I am very grateful now that this Liberal Party of Canada and my Liberal colleagues here at this committee actually appreciate that there is a place in our Canadian justice system for mandatory minimum penalties, because those who would seek harm by extorting the precious assets that largely our immigrant population has built up in this country, to take that from those individuals needs a strong response from parliamentarians. So thank you to my Liberal colleagues after criticizing you appropriately in my intervention for seeing the light and recognizing that there is a place for mandatory minimum penalties, and a 4-year mandatory minimum penalty where a firearm is used in extortion is highly appropriate, and it's time to reflect that as soon as possible. Thank you.
Mr. Gill.
Mr. Chair, and I want to speak to Mr. Brock's motion because it is relevant to my riding. I know he mentioned across country the extortion crisis is on rise, and we all know that extortion is up 330% in Canada, and it is a crisis in my hometown, Brampton. It is a crisis because of catch and release, bail policies, and illegal firearms the Liberals have allowed across the border. We have seen drive-by shootings at businesses, at homes in broad daylight. The criminals, they send the victims video of them shooting at the victim's home. Extortion is causing an exodus of business owners who are scared for their safety. And we know, and we are talking about how important to control this crime in our neighborhoods and on our streets. It does not capture the cases where the firearm is illegally held because the person does not have a license or the firearm was smuggled across the border. These cases are the majority of extortion cases in my community and in my town. This would simply aid a 4-year MMP, mandatory minimum penalties, if a non-restricted firearm is used. I encourage everyone to vote for Mr. Brock's amendment to clearly denounce extortion with any firearms. I'm supporting it. I will encourage all of you to support it. Thank you.
Ms. Latanzio?
And I'd like to ask officials a few questions. So the first one being, would this be charter compliant? And what would it do in terms of delay? Would it risk increasing the delays?
Thanks for the question. Difficult to say in the abstract whether it would be charter compliant, but I would point the committee to the Hillback decision, which was discussed last week, where the Supreme Court of Canada did uphold 2 mandatory minimum penalties of imprisonment for robbery with a firearm. So that would be certainly, I think, instructive in any charter challenge in this space, given the offenses are similar in terms of their seriousness and would have some similar penalties. Certainly on the delays issue, to the second part of your question, that was one of the objectives that animated C5 at the time, in addition to some of the objectives that Mr. Brock has spoken about already. There was a significant concern around justice system delays, that there had been a fairly significant number of charter challenges. There was a disincentive for individuals to plead guilty, and therefore their trials would continue. So one would expect that those kinds of considerations would continue to be relevant in any offense where there are mandatory minimum penalties of imprisonment.
Mr. Chair, can I ask to suspend a couple of minutes?
Yeah, you absolutely can. We'll suspend
Thanks.
it. to order. Ms. Latanzio, you still have the floor.
Thank you, Mr. Chair. So we discussed amongst ourselves, and we, I think, have an agreement to be able to defer the vote on this one at the very end of the meeting, Mr. Chair.
We have agreement on that? Okay. Okay. All right. Thanks. So that takes us to Mr. Bauer.
Does that bump the speaking list then?
No, this would carry over to the end. That's all. We'll pick up at the end on this where we left off.
Can I speak to it now? Am I able to complete my submissions?
Sure. Go ahead. Well, Ms. Latanzio still has the floor technically, but
That's it.
you're done? Okay.
Request.
All right. Go
Thank
ahead,
you.
Mr. Bauer. All right.
Mr. Brock is moving an amendment to mandate a 4-year mandatory minimum sentence when a firearm is used in the commission of an extortion offense. We are witnessing horrible videos on the news and social media in the Greater Toronto area of people shooting at residential houses, at mobs, shooting at homes in the middle of the night repeatedly to demonstrate their strength, to flex, to threaten people to do something that they otherwise wouldn't do, and that is typically to pay money. It is unthinkable that we have a crisis of extortion around Canada right now. Unfortunately, this is something that my family has witnessed, but not in Canada. My aunt owned a flower store, and she was compelled in Haifa to pay protection money. And when she didn't, her flower store was burned down to the ground. And then she didn't again, and her flower store was again burned down to the ground. This is not arson. This contemplates a firearm. I think that extortion, when mobs, and in this case we often deal with foreign mobs, intervene in our small business climate and start extorting people for money, that's where the rule of law breaks down. This is not an offense against the administration of justice, but it undermines the rule of law so fundamentally that justice in itself is now in doubt. This bill gives us an opportunity to address this crisis that I heard the Justice Minister discuss in the House multiple times. Now, I'm very pleased that the Chair has ruled this amendment in order. I point out that the Chair has used a previous amendment where a firearm is used in a robbery, a minimum mandatory sentence to be prescribed was to be ruled out of order. This one's ruled in order. The Liberals have an opportunity to do something very, very important. Thank you.
Thank you, Mr. Bauer. Okay, so we're going to defer that until the end, which also includes voting on Clause 37, which takes us to new Clause 37.1, including CPC 21.1, which I am ruling out of scope.
Out of scope.
Yeah. It's new Clause 37.1 and CPC proposed amendment 21.1.
Chair, you don't believe that's an expansion of an existing?
I've made my ruling, Mr. Bauer.
Challenge.
Thank you. Mr. Clerk?
Yes. On the motion, shall the Chair's ruling be sustained? Madame Latanzio?
Yes.
Monsieur Housefather?
Yes.
Monsieur Chang?
Yes.
Monsieur Rana?
Yes.
Madame Khalid? Monsieur Saint-Pierre?
Oui.
Mr. Brock?
Illogical and
Yes or-
shameful
yes or no,
expression of
Mr.
the
Brock? It's yes or
responsibilities
no,
of the
Mr.
chair. The
Brock?
answer is absolutely not.
Okay, thank you.
Mr. Baber?
No.
Mr. Gill? No. Mr. Lawton?
No.
Monsieur Fortin? Oui. Carries. Sustained.
All right, so that takes us to Clause 38, right? Yeah. Yeah. Okay, Clause 38, G26. Ms. Latanzio.
Thank you, Mr. Chair. So the motion proposes to amend Clause 38, which would amend Section 46.1 of the Criminal Code to make testimony with the support of a person or animal presumably available for victims in proceedings related to any offense committed by an intimate partner. This amendment would require a consequential amendment to subclause 2.1 in order to remove the reference to subsections 46.1 from subsection 3.012, expanding the availability of testimonial aids to all intimate partner offenses, recognizes that power imbalances and fear can affect a victim's ability to testify even in the context of non-violent offenses, since other unreported abuse may be present.
Thank you. Okay. Shall G26 carry? Yes. Carried. Shall Clause 38 carry? Yes. Carried. Takes us to Clause 39 and NDP 16. Ms. Kwan. Actually, hold on. If NDP 16 is adopted, G27 cannot be moved due to a line conflict. Ms. Kwan.
Thank you very much, Mr. Chair. So on NDP 16, so this is a similar amendment previously moved, and this would extend the procedural protections to all those who are victimized by an intimate partner and would not restrict procedural supports to a limited number of offenses. So what's important here is about these protections in legal proceedings is the context of domestic violence and not the particular offense. So I hope that the committee members would support this as they follow the recommendations of experts in this request for amendment.
Thank you. Ms. Latanzio.
Mr. Chair. So our government agrees with the objective of this motion. We are trying to achieve the same outcome, Mr. Chair, which is to expand the access to testimonial aids for victims in proceedings involving intimate partner violence. However, we cannot support this amendment as drafted. We have put forward our own amendments in G27, which achieves the same result, but does so with clearer and more consistent language across the criminal code, including alignment with the French version. That matters because if we want these protections to work for victims, the law has to be clear and applied consistently by the courts. So this is not a disagreement in theory. We are just aligned on that. It's about getting the drafting right. So for those reasons, we'll be voting against NDP 16 and moving G27 to ensure victims receive the protections they need fully to participate in the justice process.
Thank you, Ms. Latanzio. Okay, shall NDP 16 carry? Okay, defeated. Okay, which takes us to G27, which I assume is you, Ms. Latanzio?
So this motion proposes to amend Clause 39, which would amend Section 46.2 of the Criminal Code to make testimony behind a screen or outside of the courtroom by CCTV or other means presumptively available for victims in proceedings related to an offense committed by an intimate partner. This amendment would require a consequential amendment to subclause 2.1 in order to remove the reference to Section 46.2 from subsection 3.1 Paragraph 2, expanding the availability of testimonial aids to all intimate partner offenses recognizes that power imbalances and fear can affect a victim's ability to testify, even in the context of non-violent crimes, since other unreported abuse may be present.
Thank you. Okay, shall G27 carry? Yes. Shall Clause 39 carry? Yes. Carried, both carried. Clause 40, start with G28. Ms. Latanzio.
Mr. Chair, again, the same reasoning that was just mentioned in G27.
Thank you. Shall G28 carry? Yes. Carried. Shall Clause 40 carry? Yes. Carried. Shall, okay, so we're now into new Clause 40.1. It was NDP 17. Ms. Kwan.
Thank you very much, Mr. Chair. So this amendment is based on a recommendation from the National Association of Women and the Law to ensure that victims are not a risk of criminalization for a breach of a publication ban, whose purpose is to protect victims themselves. While past legislation has responded to concerns raised by survivors about this issue, experts tell us that these measures have proven to be overly narrow and that this remains a major risk for victims. With this in mind, I urge the colleagues to vote in favor of this amendment to uphold victims' rights and to ensure that survivors of violence are not criminalized due to the same publication bans that are supposed to protect them.
Ms. Latanzio?
Yes, I would have a question for the officials.
Guys,
In the
guys.
proposed amendment, would this not undermine the reforms already enacted through former Bill S-12 that already allow victims and witnesses broad freedom to speak about their cases while preserving protections for other individuals whose identities remain subject to a ban?
Thank you for that question. Yes, through the chair, I agree that it would conflict with subsection 486.6 sub 1.1, which was enacted, as the member said, through former Bill S-12. That provision basically says that a victim can't be held liable for breaching a publication ban unless they knowingly failed to comply with the order, they compromised the privacy interests of another person who was also protected by a publication ban, and a warning to the individual was not an appropriate response. So those are the safeguards that are already built into the code to ensure broad leeway for victims to speak about what they have endured. Thank you.
Okay, Mr. Housefather?
Just one question. Thank you very much for my colleague for the question, for the clarification. As I would read the proposed new language, what it would essentially do, it would say that the person who is failing to comply with the ban is exempt from any sanctions, even if, for example, they breach the privacy of another witness or another person who was also a victim. Is that correct?
Mm-hmm. That's correct. That's how I read the amendment as well.
Okay, shall NDP 17 carry? No. Defeated. Shall clause 41 carry? Yes. Carried. Okay, clause.
Sorry, Mr. Chair. I just want to make sure NTP 17.1, I guess that's under clause 59.
Sorry, I couldn't hear you. Can you say that again?
I just want to make sure that NTP 17.1 is in the package, and that comes in clause 59. I just want to make sure that you have that because it's been an updated package.
Give me a second.
Yeah? Okay.
Yeah, it is.
I
Okay.
see the legislative clerk nodding, so thanks.
Yeah, Mr. Berber.
Are we able to vote on the clause as we just did, given that we have CPC 21 still outstanding for consideration?
Sorry, clause 40.1?
We just voted on a clause, but I believe that that clause is still not finalized because we're dealing with CPC 21 still. So should we not defer the voting on the clause as well?
No, it's a different clause.
It's a different clause?
Yeah.
Okay.
Yeah. Okay, so we're now on to clause 42, but PV5, I believe, has been withdrawn. Yes. Yeah, okay. Okay, so shall clause 42 carry? Yes. Carried. Shall clause 43 carry? Yes. Carried. Shall clause 44 carry? Yes. Okay, so we're into clause 45, which is all PV6, which is withdrawn, so shall clause 45 carry?
You can group them if you want to 55.
Okay. Shall clauses 46 to 55 carry? Yes. Carried. Clause 56, which is G29. Ms. Cowd.
Thanks, Chair. This is basically just cleanup language to make sure that the French version is the same as the English text as well. So it just adds grammatically correct language that's consistent with the English version.
Thank you. Okay, shall G29 carry? Yes. Carried. Shall clause 56 carry? Yes. Carried. Shall clause 57 carry? Yes. Carried. Shall clause 58 carry? Yes. Carried. Okay, clause 59, which takes us to G30.
I'll speak to it, Mr. Chair. So this is a technical.
Sorry.
Yeah.
Go ahead, Ms. Lepenzio, okay.
Thank you, Mr. Chair. So this is a technical amendment. This motion would amend the English version of Clause 59 to amend proposed paragraph 715.48, paragraph 1A, to specify that prosecutors may issue a warning to a person.
Shall G30 carry? Yes. Carried. Now we're on to NDP 17.1, Ms. Kwan.
Thank you very much, Mr. Chair. So this amendment follows a recommendation from the Union of BC Indian Chiefs to explicitly list Indigenous diversion programs as one of the options of alternative measures in the restorative justice framework. This will ensure that alternative measures are culturally appropriate and responsive to the distinct needs and realities of Indigenous peoples accused and Indigenous victims. And we know that successive governments have embraced Sicario approaches to public safety, ignoring that Indigenous peoples are disproportionately impacted by these approaches due to a pattern of systemic.
So, Ms. Kwan, I'm going to ask you, I've got three people trying to talk to me at the same time here.
Okay.
I'll let you finish, and then I'm going to suspend for a moment.
Sure. Just finishing up that last thought, I was just saying that often successful governments have ignored these approaches due to the pattern of systemic racism in our criminal justice system and an ongoing legacy of residential schools in Canada. So while it's reassuring that this bill contains a restorative justice framework, it is essential that we do not ignore the voices of Indigenous peoples and that alternative measures incorporate culturally appropriate practices for all Indigenous communities. And this would help ensure that this bill does not contribute to the systemic racism experienced by Indigenous peoples in the criminal justice systems. Given the duty of lawmakers to ensure all legislation aligns with the advancement of reconciliation, I urge my colleagues to vote in favor of this amendment.
Thank you, Ms. Kwan. I apologize for the interruption. Okay, shall NDP 17.1 carry? Defeated. Okay, NDP 18, back to you, Ms. Kwan.
Thank
you know
you,
what, I am going to suspend just for a moment. 1 second, Ms. Kwan.
Thank you. So disappointing that the last amendment did not go through from the NDP, as it was really important for the Indigenous community. So on NDP 18, also relating to alternative measures in the restorative justice framework, this amendment would broaden protections for participants in alternative measures so that any statements made by persons alleged to have committed an offense or by victims will not result in their criminalization. It is essential that the alternative measures lay out this in the restorative justice framework, and that they do not jeopardize and are not jeopardized due to participants' fears that statements they make while completing these programs will be used to criminalize themselves or others. So if we're serious about non-carceral approaches to public safety, particularly for Indigenous, Black, and other people of color who are overrepresented in the criminal justice system, we must ensure that these solutions work and are trusted by all that are participating in them.
Thank you, Ms. Kwan. Mr. Bauer.
I'm not sure that we're able to amend civil statute or civil process by virtue of Criminal Bill C-16. We have to tread carefully. There's a charter right against self-incrimination, but I'm not sure that there's a charter right not to incriminate oneself once you chose to make a statement. So I don't know. I'm a little confused by this.
Okay, shall NDP 18 carry? No. Defeated. Okay, G31. Ms. Collett.
It's a technical amendment, so it would basically amend Clause 59 to expand the proposed Section 715.56 so that the records regime in the new part on alternative measure and restorative justice processes would also apply to records of warning and referrals made by prosecutors, in addition to those that are made by the police.
Thank you. Okay, shall G31 carry? Yes. Carried. Shall Clause 59 as amended carry? Yes. Carried. Shall Clause 60 carry? Yes. Carried. Shall Clause 61 carry? Yes. Carried. Shall Clause 62 carry? Yes. Carried. Takes us to Clause 63, starting with NDP 19. If NDP 19 is adopted, CPC 22 cannot be moved to because of a line conflict. Ms. Kwan.
Thank you very much, Mr. Chair. So this NDP amendment reflects concerns raised by a range of experts and stakeholders about the Liberals' reinstatement of mandatory minimums, which have repeatedly been struck down by the courts for violating charter rights. This change would ensure that Bill C-16's safety valve would include the GLADU principles to consider non-carceral options for Indigenous people and the protection of the charter rights in all cases. This would mean aligning this legislation with the government's commitment to implementing Call to Action 32 of the Truth and Reconciliation Commission and upholding equality for those overrepresented in prisons, including racialized people, victims and survivors of abuse, and those dealing with mental health and addiction issues. This committee has heard from several legal experts that have recommended amendments to broaden the safety valve in Bill C-16, including the National Association of Women and the Law, the Women's Legal Education and Action Fund, the Canadian Bar Association, and the Quebec Bar Association. Elected representatives have a duty to uphold our charter and our commitments to reconciliation, so I strongly urge my colleagues to follow the recommendations of legal experts and vote in favor of this amendment.
Thank you, Ms. Kwan. Mr. Brock?
Thank you, Chair. To the officials, am I correct in my interpretation that after C-16 receives royal assent, that wherever in this country a judge finds that the application of an MMP would result in cruel and unusual punishment, would still avail that particular justice to consider 718 in the context of the GLADU principles as it relates to an Indigenous offender? That would happen regardless, correct?
Question. Yes, that's correct.
Thank you.
Shall NDP 19 carry?
No.
Defeated. Okay, CPC 22.
Out of scope? Thank you, Mr. Chair.
No.
I never know what to expect.
I'm trying to keep you on your toes, Mr. Brock.
Very happy to speak to CPC 22. And listen, colleagues, I come to this with the realization that notwithstanding our overarching concerns regarding the applicability of safety valves, for the reasons I have articulated far too many times about the built-in residual discretion that already exists, I'm addressing, in this particular amendment, I'm addressing another elephant in the room, and it's to recognize that notwithstanding the preferred language of the Liberal government that sees criminal justice system through, I believe, an artificial lens, that every particular judge in this country will do the right thing, that there is consistency in sentencing. And I couldn't disagree more with that general proposition. We're all lawyers. Most of us are lawyers in this room, and some of us have all done some trial work. We will all agree that there is great discrepancy that exists even within a judicial district, that differences exist in Western Canada in terms of sentencing versus Eastern Canada. I can cite numerous examples. But the point I'm trying to make here is if we want to ensure consistency, there's an opportunity for all of us here at the Justice Committee to put some guardrails in place, because Bill C-16 as drafted does not provide any direction whatsoever to a justice, with the exception that you shall not deviate for murder, you shall not deviate for treason. But there is no instruction on how a judge, whether that judge on his own or her own, or by application of the accused, or by application by the accused representative or friend of the court, brings to the attention the possible applicability of deviating from an MMP. So what better opportunity for us as parliamentarians to strengthen a bill that on its face has a glaring weakness? And that weakness is no direction, a base direction to a sentencing justice. So I've used language such as, well, let's look at factors. If the offender has no prior criminal record, could be a factor to deviate. Any evidence of mitigating circumstances, and by no means is this list exhaustive, such as evidence that the offender cooperated with law enforcement officials or pled guilty very early on in the process. Now, I didn't on my own come up with an exhaustive list because the list was not intended to be exhaustive, but what I did do in terms of my own research into the drafting of this particular amendment is I did a comparison of other jurisdictions that do provide their jurists with some degree of instruction where there is a deviation from an MMP. It exists in the UK, it exists in Australia, it exists in America in a number of states. But if C-16 passes, receives royal assent, again, our country will be an outlier in the criminal justice field. So that's one aspect of that particular amendment. The second aspect is something that we all need to accept as reality. And if you recall, colleagues, on the last occasion, that being Wednesday, I asked a question to officials, and Mr. Taylor, you took responsibility for answering the question, that there currently is nothing in C-16 to prevent a justice from imposing a one-day sentence. Because the language, the only instruction that C-16 provides is that where you deviate, you still must have a custodial sentence. I used as an example a one-day sentence. Could be deemed to be a legal sentence under C-16 as a deviation. A time served disposition can be deemed to be an acceptable sentence under C-16. So what I chose to look at is take a look at those examples that exist out there. And I used this as an example last Wednesday, if you recall, colleagues. Senneville, that pervert who received the benefit of our Supreme Court of Canada's wrong decision in Senneville. He was originally sentenced, notwithstanding the size and the depravity of the collection of child sexual abuse material, a 45-day weekend sentence. If anything, that one-year mandatory minimum penalty should be increased, because there has been no abatement of the creation of this filth in this country and around the world. There is such a growing appetite for this abuse material. Here is an opportunity for us here in Canada as parliamentarians to take an appropriate stand. If anything, if I had some ability to direct policy in this country, I'd increase it to 3 years without any hesitation whatsoever. because it is a sickening, sickening offense. So I said to myself, well, how best can we at least reassure victims? How can we establish some degree of accountability and deterrence and denunciation? A one-day sentence is, in my view, is tantamount to a fraud on our criminal justice system. I'm just going to use one example. I'm not going to waste too much time, but I think this example is appropriate. My old life, I think we all can experience this, that some judges were harsher than others in our various jurisdictions. In my jurisdiction, I had a female justice. I was in her guilty plea court one day, and I looked at the case file, and I said to myself, why on earth is an offender from Kapuskasing, Ontario, some 8, 9, 10 hours away from the Brantford jurisdiction, why is he waiving in his guilty plea when he's already in custody and could have proceeded with his guilty plea in that jurisdiction? So I was curious. This female judge in Brantford was curious and asked the question. And the offender, if anything, was extremely honest. And he said, well, Your Honor, you've got quite the reputation in Ontario. And I heard that we can easily pull on your heartstrings. And he laughed, and the judge laughed. And guess what happened? It worked. She gave him a sweetheart sentence. He thanked her profusely. He got the job done. That is what happens every single day in our criminal justice system. We've got accused and defense counsel who routinely play games. It's called judge shopping. And anyone who says it doesn't exist, I've got a plot of swampland in Florida for me to sell to you, because unfortunately, folks, it does exist. So I said to myself, well, how can I put some limitation on that? And what I did in the second aspect of 22 was to suggest that where there is evidence that a mandatory minimum penalty could result in cruel and unusual punishment, you are forbidden as a jurist from undercutting that sentence by more than 50%. That, in my view, provides a little bit more control and consistency in our justice system. And that was my rationale for invoking the amendment contained in 22. Thank you, Chair.
Thank you, Mr. Brock. Mr. Bauer.
Sometimes I wish the viewers at home understood what actually happens in this committee, the legislation that comes before this committee, and what this Liberal government is doing. The whole premise of Bill C-16 is to address a number of offenses that should have been addressed a long time ago, but most importantly, mandatory minimum sentences that are being struck by judges every day. We all know basic criminal code language. If you commit offense X, then you shall be sentenced to a minimum of Y or a maximum of Z. And we have seen time and time again judges strike down the mandatory minimum sentence. So here come the Liberals with the Attorney General and Justice Minister and say, oh, we're going to fix the fact that judges are striking down mandatory minimum penalties every day, and we're going to do it with the so-called safety valve. And that, in my view, is the most critical piece of this Bill C-16 legislation. And what the Justice Minister says, and what the Liberals would have us believe, is that the safety valve allows judges not to look at a reasonable hypothetical, a non-existent scenario before them, and then go ahead and strike down a mandatory minimum sentence for being cruel and unusual when it's applicable to that hypothetical scenario. And instead, look at the accused before them and say, under the circumstances, it would be cruel and unusual to impose the mandatory minimum sentence. And the Liberals say that by virtue of the existence of the safety valve, that mandatory minimum penalties will actually be preserved. So now I want to go to the officials. Mr. Taylor, am I correct? The policy of the Justice Department and of the government is that the safety valve that is put before us is going to strengthen mandatory minimum penalties, yes or no?
Well, the proposed safety valve is a policy proposal of the government, not a proposal of the Department of Justice, but in explaining how it operates, the idea is to, as I discussed last week, is to reinforce and reanimate MMPs that have been found unconstitutional by different levels of the court in Canada. So it provides an ability to depart from the imposition of the MMP in a specific case where that MMP, in relation to the specific offender, would amount to cruel and unusual punishment.
But Mr. Taylor, the premise that the government is operating under is this will actually preserve mandatory minimum penalties, but for instances where judges believe that under the circumstances before them, the penalty would be cruel and unusual, correct?
Correct.
Okay, so the government is saying mandatory minimum penalties means the safety valve means stronger mandatory minimum penalties, correct?
Means that MMPs will remain in place.
Excellent. However, the safety valve has two notable exceptions for two notable offenses. One is murder, and the other one is treason. Okay, so the safety valve, the Liberals say we're going to use the safety valve to strengthen mandatory minimum penalties, but the safety valve will not be available to strengthen, supposedly, offenses of murder and offenses of treason. Why were these two very serious offenses, maybe the most serious offenses in the criminal code? Mr. Taylor, can you tell us why were they left out from the application of the safety valve?
Yeah, certainly from the perspective of the penalty imposed, the mandatory penalty of life imprisonment, they are the most serious offenses from a sentencing perspective because they do carry the most significant penalty of imprisonment. Unlike other areas of criminal law and sentencing law in particular, these mandatory penalties have not been the subject to significant charter litigation. They have been upheld. In the context of murder, I'm not, and I'll check to my colleague if treason has ever been challenged constitutionally. I don't think it has. And to pick up on a comment I made earlier in response to a question, we have not seen, in respect of those specific offenses, the same kinds of concerns around trial delay, guilty pleas, things of that nature in that context as compared to the other types of offenses.
Basically what you're saying
Sorry,
is...
I'm just going to interrupt you for a second, Mr. Barber. The bells have are ringing, so we'll need unanimous consent to continue.
Can I just, yeah, thank you. I'd like to finish.
Well, I'll allow you to
Thank you.
finish, Mr. Barber. This is a procedural issue we have to deal with, so if you just be patient. Do I have unanimous consent? Yes. Okay, thank you. Mr. Barber, please continue.
Mr. Taylor, I believe that it's very instructive that the Liberals are telling everybody that they're using the safety valve to strengthen mandatory minimum sentence, but they do not apply the safety valve to the most serious offenses of murder and treason. That in and of itself defies logic and exposes the argument for the safety valve as not doing what it intends to do, but doing quite an opposite. It is not strengthening mandatory minimum sentences, because if it did, then the Liberals would apply the safety valve to murder and treason as well. It weakens mandatory minimum penalties. We are we're living in a crazy environment. We all door knock, we all talk to voters. I come from the city of Toronto, where crime right now is the most important issue for voters. People don't feel safe walking the street of downtown Toronto. They don't feel safe taking the TTC. They don't feel safe in their local neighborhoods in North York. We need to take a bite out of crime. We need to strengthen mandatory minimum penalties, not weaken them. And what we've been seeing from the judiciary, with respect to the judiciary, is the undermining of mandatory minimum penalties. Mr. Brock is proposing an amendment, a reasonable amendment, to put some sort of parameters around the safety valve, parameters that exist in other jurisdictions. Will the Liberals please not undermine mandatory minimum penalties and put some sort of framework around this proposed safety valve by passing Mr. Brock's amendment? Thank you.
Thank you, Mr. Bauer. Ms. Latanzio.
Thank you, Mr. Chair, and I thank my colleagues for their intervention. My question to the officials, it seems to be quite clear that the amendment proposed would undermine the constitutionality of the safety valve, which I may point out is fully supported by a Conservative member, more specifically the member for Kamloops, Thompson, Caribou, who is in full agreement of the use of the safety valve. So I just wanted to know if that is your understanding, that it also limits judicial flexibility, because this isn't about going easy on anyone. It's just making sure that the law works for the people that it's intended to protect. So I just wanted to have your thoughts on that.
Question. So as currently drafted, Clause 63 tracks the constitutional standard, so affording judicial discretion to impose a shorter term of imprisonment only where the MMP would constitute cruel and unusual punishment for the offender before the court. So the inclusion of additional mandatory criteria could mean that proposed judicial discretion would be unavailable in some cases where the MMP would otherwise constitute cruel and unusual punishment. So for example, where an offender has a criminal record, this could raise charter issues. Additionally, excluding financial hardship could further impact judges' ability to assess whether the impact of a particular MMP would constitute cruel and unusual punishment, because the Supreme Court of Canada has made clear that financial hardship can be relevant to the assessment under Section 12 of the Charter. And then additionally, the proposal to limit judicial discretion to impose nothing shorter than a half of the MMP could also reenact existing charter vulnerabilities, because we know of several cases where courts have found that even half of an existing MMP could constitute cruel and unusual punishment, and Centerville is an example of that, because in that case they said that for the reasonable hypothetical offender, the proportionate sentence would be a conditional discharge. So if an individual presented with similar facts to the reasonable hypothetical in Centerville, it could be that even a 6-month MMP, which would be half of the existing MMP, could constitute cruel and unusual punishment. So the short answer would be yes, it could introduce new charter vulnerabilities.
Thank you.
Thank you, Mr. Housefather, and then Mr. Brock.
Yeah,
Mr. Housefather.
Sorry, Mr. Housefather.
No problem. Thank you, Mr. Chair. I think that with respect, I just want to come back on some of the stuff that Mr. Weber said, because, of course, this bill essentially reestablishes MMPs that were struck down by the courts. So, of course, this bill furthers the goal of ensuring that MMPs remain in place, because otherwise they would remain struck down. This bill creates a mechanism by which courts can determine whether or not somebody's individual circumstances, as opposed to using a reasonable hypothetical, would invalidate something for that person instead of for the entire group of offenders. So no longer will courts be using reasonable hypotheticals. They will be looking at the individual charged with the offense, and they'll be determining if the MMP is inapplicable to them, and then you have suggested wording that is consistent with that principle, which is whether it would be cruel and unusual. And Mr. Weber is now seeking to introduce other elements into the factoring. So I want to first start. Mr. Weber was arguing that not including murder or treason somehow is illogical. To me, it's completely illogical, because we're assuming that murder and treason are such offenses that nobody would ever question an MMP for those heinous offenses. And they have not been the subject of debate in the courts that could lead to them being struck.
Mr. Byron, Mr.
I don't know what you're doing
has the
now.
floor.
I let you speak, okay? We don't believe that there's a hypothesis under which a reasonable hypothetical is going to allow a court to strike down a murder or a treason offense so there was no need to include that here. Is that essentially, am I correct in that supposition, that because these are such heinous crimes that we feel that we can exempt them from this, from the safety valve, because they would never be struck down in the first place for anybody? Would that be correct?
answer the question a slightly different way, perhaps. Minister Fraser, I think before this committee and when he appeared the week before last before the Status of Women Committee, indicated one of the specific concerns that the government was trying to address in relation to this specific escape clause was the unintended impact that the increased use of MMPs has had in outlier cases. And so that, I think, speaks to what you're saying, Mr. Housefather, is that what we have seen is a proliferation of charter challenges to MMPs that have been enacted for very specific reasons that Parliament deemed appropriate in passing that legislation. But in so doing, there were instances, kind of outlier cases, that were of concern. And that is what this escape clause is seeking to do, is to address those outlier cases, as Ms. Burt has talked about, and maintain them, the MMPs, for the vast majority of cases, remembering that at the end of the day, a fit sentence is a fit sentence, and that can be in excess of the mandatory minimum penalty, and in exceptional cases, because cruel and unusual really is meant to be exceptional, it may be less.
And I agree completely with what you just said, and you phrased it very well, and thank you very much. So I guess then coming to it, Mr. Brock has suggested a list of other factors that we would be looking at in addition to cruel and unusual. And you've mentioned two factors, one of which is saying that no sentence could be less than half of the mandatory minimum. I guess my question to you guys is that obviously this would lead to far more charter challenges by adding the wording proposed by Mr. Brock than the wording that is initially in the legislation. Would you agree with that hypothesis?
Thank you for the question. I think it's likely that, yes, this would result in increased charter litigation.
And we're not in a situation where it's simply a legislator that is making a decision without the benefit of court judgments that we've been looking at for now. The charter has been in effect since the 1980s for years, where you opined upon where we could draw the line on the safety valve clause, and advice, I presume, was given that this is a reasonable area to confine it to cruel and unusual punishment. Is that, or where the minimum mandatory would be cruel and unusual based on the circumstances of that offender? Is that essentially what your advice was? If you can give it, I know you can't give your legal advice to the department, as Department of Justice to the minister, but is that, are you? I guess my question would be, if we added in the new wording, would you be comfortable at that point on defending charter challenges?
So with the additional
the additions of Mr. Brock.
Yeah, I think Ms. Burt has pointed out that the additional criteria which we would read would be necessary in addition to finding that the potential penalty would amount to cruel and unusual punishment would not be sufficient. You would have to go beyond that and also show that, for example, the offender had no prior criminal record. So I do believe that would invite additional charter litigation.
Okay. Thanks. Thank you.
Thanks, Mr. Housefather. Mr. Brock, and then Mr. Brown.
I am so deeply, deeply disappointed to hear this running theme of this could potentially happen, that could potentially happen. Let's face it, the entire Bill 16 is susceptible to charter challenge, yes or no? Mr. Brock, as I've said in response to other questions before this committee, it is always possible. Absolutely. That legislation can be challenged. Everything is possible. And I listened to you very carefully, Ms. Burton, with all due respect. It may snow tomorrow. It's quite possible. Right? Like, all I'm hearing from my Liberal colleagues is, could this result in increased charter challenge? Since when are we, as parliamentarians, so concerned about the potential for charter challenge? When are we going to do our damn jobs and protect Canadians and ensure that we provide justices with the appropriate tools to do their damn jobs of holding offenders accountable and keeping communities safe? That is our role. Our role is not to go into the minds, into the shoes of a jurist. Because let's face it, this is what's going to happen, folks. Mr. Housefather raised this issue numerous times. Could this result in increased litigation? Absolutely. Name one accused, named one defense counsel who will not look for every opportunity when faced with a mandatory minimum penalty to look for an argument to deviate from that. With all due respect, Mr. Taylor, I disagree with you. Should be reserved for those outlier cases, but it's not going to stop a defendant from at least trying. And one thing that I did not highlight, and this is to your point, Ms. Burt, is my amendment in 22 talks about financial hardship and specifically excludes the issue regarding loss of housing or employment as not a relevant circumstance. So let's take a look at mandatory minimum penalties that currently exist in the criminal code for impaired care and control operation of a conveyance. That's the term they use now instead of vehicle. We have mandatory minimum penalties in terms of fines, and where there is subsequent convictions, actual jail. Again, name one accused who have not used an argument. Oh, Your Honor, I can't go to jail. I'm the breadwinner of the family. My family is going to suffer. I'm going to lose my job. I can't go to jail for 90 days on my third, fourth, or fifth impaired because I haven't got the message yet. I want that door to be closed as tight as possible, and I think we should be doing the same thing as legislators because Pandora's box is wide open on this issue. So to you, Ms. Burt, Mr. Taylor, Ms. Levman, Ms. Seguin, can you name one particular case where there has been a successful challenge to the mandatory minimum penalty where financial hardship in and of itself constituted cruel and unusual punishment? Can you name one case? I certainly can't.
Thank you for the question. No, we wouldn't have that information at our fingertips at the moment.
I could give you a whole year to look into that matter, and I dare say at the end of 1 year, you still wouldn't be able to find anything. My point exactly. We are inviting a whole spectrum of legal arguments to be used every single day in courts across this country if we don't give our jurists some direction. That's the problem, folks. And I'm urging you seriously to consider my amendment.
Thank you, Mr. Brock. Mr. Bauer?
Yeah, it's actually considerably worse, I think, Mr. Brock, because what the safety valve will do is it will say, you no longer even need to bring a charter application to say that the mandatory minimum penalty would be cruel and unusual. The safety valve eliminates that requirement for a charter application. Am I correct, Mr. Taylor? Every single time an accused would be sentenced, a judge would give consideration to whether the sentence is cruel and unusual.
Would you mind repeating the question, please? Thank you.
Right now, the practice is if an accused wants to challenge a mandatory minimum penalty as cruel and unusual, they ought to bring a charter application. It's a step in the process. What the safety valve does is it eliminates that step in that every single time an accused is up for sentencing, the judge would essentially be directed by Bill C-16 to consider if a sentence is cruel and unusual.
Yeah, thank you for the clarification. So in my answer last week, what I articulated was our expectation that at the sentencing stage, or perhaps during the trial, the defense counsel representing the accused at the trial stage or the offender at the sentencing stage would indicate their intention to seek a sentence that is less than the mandatory minimum penalty on the basis that vis-a-vis their client the offender in this case, would be cruel and unusual. So we do still expect, not as a constitutional argument, but as part of the sentencing process, a step taken on the part of the accused/offender's counsel in terms of sentencing.
Thank you, Mr. Taylor. I think you're agreeing with me in that essentially now an allegation of cruel and unusual punishment would be almost as part of a standard operating procedure as opposed to a constitutional challenge. Members opposite to me must understand this. This in and of itself weakens the mandatory minimum penalty. But wait, there's more. I mean, what are we talking about when we talk about a cruel and unusual punishment? At the end of the day, the court does a weighing exercise in terms of what's reasonable or not. That's all it is when it comes to mandatory minimum penalties being cruel and unusual. I have to be honest. You know, throughout our political careers, you often try to reach out across the aisle, and I'm proud of my professional relationship with Mr. Housefather. We often see eye to eye on many issues, and it's a necessary bridge in committees such as this when you can approach your friend from the other side of the table and try to be reasonable with each other. Mr. Housefather responded to my contention that there is no intention to strengthen mandatory minimum penalties because an exception is made for treason and murder, which on the scale of murder, turpitude probably are at the top of all evils. So then why, I ask, we pretend that we're going to be strengthening the mandatory minimum penalties for all other offenses? And Mr. Housefather's suggestion, and I think Mr. Taylor sort of alluded to that, was, well, they're generally not as susceptible in that they are so evil that generally courts try not to depart from them. Okay, well then I asked Mr. Housefather, how about possession of child pornography or access to child pornography? Or how about sexual assault? Do those offenses not rise to the level of turpitude where we should strengthen them as opposed to weakening them? Here we are, by our own admission, saying there are greater evils that we don't want to depart from, because it's not about the strengthening. It's about departing from the mandatory minimum penalties. For murder and treason, we will not. But for sexual assault or possession of child pornography, we will. This is an absurd result that we are now arriving at. I've been waiting for this for months now, and I think my liberal friends are understanding this. And you know what will happen? We're going to be here again in a couple of years. In a couple of years, we're going to have a governor, we're going to have an attorney general, we're going to have a justice minister saying we need to address crime on our streets, and we're going to do this all over again. We've built through this with Bill C-5, Bill C-75. We've done very comparable work on 14, which came short, and now again 16, I think, is undermining the administration of justice.
Only for 1 second. We're under 10 minutes now. Does anybody intend to go to the House to vote, or is everybody going to vote here? Because if we're voting here, okay, then you can. I'm going to stop with 5 minutes to go.
I submit that when Nod, which was the other applicant in the Centerville case, who was holding to 250 videos of children being raped, then we should approach that case with the expectation that courts will not depart from the mandatory minimum penalties, just like you do with treason and murder. And by the way, I can see everyone's brains moving when it comes to murder and treason, but it might not be as cut and dry as people think here. Think about Edward Snowden, an example that I often use when I instruct on the charter or civics. Edward Snowden blew the whistle on national security, on Homeland Security, on the NIS, on the CIA, as collecting metadata, something that is proposed in Bill C-22, indiscriminately on everybody. I ask an ordinary civics class or a grade 12 law class or a grade 11 law class, or even the first-year law students, Would you convict Mr. Snowden for treason? For coming out, leaving to Hong Kong and saying the United States administration and security apparatus are violating search and seizure? Would you convict? 9 out of 10 say they would not convict. It's a very interesting proposition that I'm advancing here. None of this is certain. What needs to be certain is certainty on sentencing. The criminal code says this is the minimum for this evil of child possession, of child pornography possession. That should be the sentence, as opposed to weakening the mandatory minimum sentences, which is what this bill is unfortunately doing. Thank you.
Thank you, Mr. Barber. Okay, I don't have any other names on the list. So shall CPC 22 carry?
Yes.
Recorded vote.
Thank you, Mr. Chair. So on CPC 22, Madame Latanzio? No. Monsieur Housefather? No. Mr. Chang?
No.
Mr. Rana?
No.
Madame Khalid?
No.
Mr. Saint-Pierre? No. Mr. Brock?
Yes.
Mr. Barber?
Yes.
Mr. Gill?
Yes.
Mr. Lawton?
Yes.
Mr. Fortin?
No. Defeated. Okay, I'm going to suspend now. We've got 6 minutes rather than start something new, and then we'll come back right after the vote.
Thank
My intention is to continue until about 10 to 2 and then suspend again so people can attend question period. So we were just about to start CP 23. Once CPC 23 is moved, CP 24 cannot be moved as they are identical. So, Mr. Brock, I believe you're going to address this?
Mr. Baber.
Sorry, Mr. Bauer then, okay.
Thank you, Chair. I move amendments CPC 23 to accomplish what Bill C-16 is meant to accomplish according to the government. It is to eliminate the use of reasonable hypotheticals when courts consider whether punishments are cruel and unusual. We heard from the Attorney General and Justice Minister that this is a concern. Just to explain to the viewers at home, an accused shows up before a judge for sentencing and pleads that a sentence, a minimum mandatory sentence, is cruel and unusual, not because of their individual circumstances, not because of the circumstances of their offense or the circumstances of their life, but what defense lawyers do is they come up with a reasonable hypothetical which would render the minimum mandatory penalty absurd. This is what happened in the Seneville decision that struck down mandatory minimum sentences for access and possession of child pornography. And the accused in that appeal, Seneville and Nod, did not plead that they should not receive the mandatory minimum of 1 year. One of them possessed 300 images, one of them possessed 250 videos of children being raped. No. The Supreme Court considered a reasonable hypothetical. One teenager sends a picture that's not too modest to another teenager, and that would lead to absurdity. And because of that, the mandatory minimum penalty was struck down. And we've been sitting here, we've been working in good faith on this bill to try and strengthen our sentencing system. And the Liberals come up with the safety valve, saying the safety valve will now enable the court to look at the individual circumstances of whether a sentence is cruel and unusual without looking at reasonable hypotheticals. So I take my Liberal friends at their word. If that is the purpose of the bill, that is the linchpin of this bill, C-16, then let's eliminate the ability of judges to refer to reasonable hypotheticals on sentencing when they decide if a minimum mandatory is cruel and unusual and is therefore contrary to the Charter. Let's eliminate this practice where judges do not look at the case before them, but look at a completely different case that is not before them and strike down mandatory minimum penalties. If the Liberals are serious about the intent of the safety valve, then they will vote for this amendment. And in connection with the same, would like to sharpen up some language. I'll yield to Mr. Brock.
Sure. Yes, I'd like to seek an amendment, I should say, amendment to CPC 23, third line down where it references for the offender, punishment for the offender, the court shall. I wish to delete the entire phrase for the offender.
3 words. 3 words.
Yep, just those 3 words.
For the offender.
Have any?
For the offender. For the 3 words. For the offender.
I see of the offender.
Is it different in French?
No, but it's.
On Mr. Brock.
The readout will then be 1.1, in determining whether the specified term of imprisonment would amount to cruel and unusual punishment, the court shall consider the particular circumstances of the offender and shall not consider any reasonably foreseeable circumstances or hypothetical scenarios?
All right, I'm going to give everybody a moment to absorb that. Mr. Fortin, you have the French language portion clear?
Ouais, ce que je comprends,
What I understand is that the main amendment will concern CPC 23, CPC 24 is the same text, apparently.
If CPC, once CPC 23 is moved, CPC 24 cannot be moved, they're identical.
OK, maintenant, on travaille sur CPC 23.
But now we're working on CPC 23. I don't understand the objective. Could Mr. Brock explain?
Vous comprenez que pour le contrevenant, ce sont les mots qui
Oui,
veulent
oui, j'ai
tuer.
compris. Ça, j'ai compris ce qu'on faisait.
I understand what we're doing, but I'm trying to imagine under what circumstances that would apply. When we talk about cruel and unusual punishment, in my opinion, it's always from the point of view of the offender. Do we have another objective? Maybe Mr. Brock will explain so I can better understand the amendment.
Mr. Brock, do you want to address that?
I wasn't even listening.
Oh.
The point.
I'll let Mr. Barber speak to that.
Mr. Bauer, go ahead.
Mr. Fortin, I think that what we have here is a drafting error by Legislative Council. The point of this amendment is to eliminate the court's use of reasonable hypotheticals. And so, as presently drafted, the amendment states, in determining whether the specified term of imprisonment will amount to cruel and unusual punishment for the offender, the court shall not consider. So what we're trying to say is we're trying to deviate from the individual circumstances, and we're trying to put it to the courts that they should not consider reasonable hypotheticals vis-a-vis the constitutionality of the legislation. I might also add that I think everybody understands the intent of the main amendment, and I'm very happy with any proposed sub-amendments, or if Liberal friends or the bloc member would like to propose any clarifying language, then I'm very much amenable to that.
Does that answer your question, Mr. Fortin?
Je suis tout simplement en désaccord avec.
I do not agree with the amendment. Once again, I don't see why we're removing for the offender. It changes nothing in the text. But, well, let's not dwell on it. Mr. Chair, on another matter, if you'll allow me, when are we adjourning for question period?
We're going to suspend at 10 minutes to 2. Okay, Ms. Latanzio?
Donc, Monsieur le Président, dans le même...
Mr. Chair, in the same vein, I understand that you said at the beginning that if we were to adopt CPC 23, CPC 24 will not stand. So my question to the colleagues, was the intention of the amendment made to preserve the two amendments, CPC 23 and CPC 24? Could you clarify?
I believe that the answer to that is no, and I believe you'll find consent. I mean, it's up to Mr. Brock to consider whether he'll withdraw his amendment. But I understand your concern. You're wondering if we amend CPC 23 as is, whether CPC 24 would still be considerable.
Yes, because the chair on the onset has established that if one is adopted, the other one drops. So my question is the amendment made in the scope or in the goal of maintaining CPC 24?
Mr. Brock?
I'm prepared, excuse me, I'm prepared to withdraw CPC 24 at this time.
Okay, which leaves us, Mr. Housefather.
Question for the officials when.
Yep, go ahead.
So I just want to understand better. My understanding is, based on the way the safety valve is drafted, there would no longer be hypotheticals that would be used for the purposes of determining whether or not a minimum mandatory sentence should be struck down or not. Am I correct in that understanding?
Yes, that's correct. The proposed Section 718.4 would require courts to consider whether a mandatory minimum penalty constitutes cruel and unusual punishment for the offender. So that would
Eliminate
exactly
hypotheticals.
eliminate the requirement to look at reasonable hypotheticals.
And can I? Then we're also using the words any reasonably foreseeable circumstances. Would there be any reason whatsoever, outside of these hypotheticals, which we understand would not be used, for reasonably foreseeable circumstances to be considered separately?
Thank you for the question. No, I think our view would be that the language in 718.41, which speaks specifically to the offender, would bar any analysis relating to reasonably foreseeable circumstances.
So in your view, this amendment, it would not only be redundant, it might even be confusing, because it would seem that with the way that we've structured the entire section, that this might still have been considered. Like I find it confusing if we're saying that you can't. I mean, there would be no reason to do this anymore. You can't do this anymore. Now we're introducing the concept that you shouldn't do this anyways. Like I just find it a bit weird. So I just wanted to understand from my head that both these things would not be part of any analysis. Thanks.
Anybody else on the sub-amendment?
The amendment, not the
sorry,
sub-amendment.
Well, it's a sub-amendment.
Ms. Burt, I have to say, with my greatest respect, while there is an intent to suggest that judges should consider whether it would be a cruel and unusual punishment for the accused, there is no prescription for the court not to consider the constitutionality of the entire section because of reasonable hypotheticals. There is nothing in Bill C-16 that says that courts should depart from that practice. And I'm saying to Mr. Housefather, why not give it greater certainty? If we believe that if what we want to do is eliminate the use of reasonable hypotheticals to strike down mandatory minimum penalties, let's clearly spell that out for the court. Now, if my friend is concerned about the words any reasonably foreseeable circumstances and just stick to hypothetical scenarios, then I'm sure that I'll find a friend on my side to move a sub-amendment to Mr. Brock's amendment. I think the chair wants to gavel us out. I invite anyone to have a conversation about this.
Suspending until after question period and after whatever votes follow question period. When we suspended, we were on CPC 23, the sub-amendment to CP 23 proposed by Mr. Brock, or was it Mr. Barber? Mr. Barber.
My sub-amendment.
Yeah, but Mr. Barber, I think, was still speaking. That's where I got confused.
Nice, Chair.
You recognized.
I appreciate that sincerely.
Can't ask questions.
So I understand that there were some concerns with respect to some other phrases within the proposed amendment. I also understand correctly from Ms. Latanzio that right now we're debating a sub-amendment by Mr. Brock. In other words, we cannot propose a subsequent amendment that will remove additional language, although I anticipate that Mr. Gill may move such amendment. I also propose at this time, just like we did with the previous amendment, to stand down CPC 23 and revisit that towards the end.
Sounds like we have consent, Mr. Barber.
Thank you.
So we're standing down CPC 24 in its entirety then?
23.
23, sorry, 23.
24 was withdrawn.
24 is withdrawn, right. Okay, so that would take us to, good. Right, we have Ms. Kwan on Zoom. Okay, so Ms. Kwan, I'll go over to you then for NDP 20.
Thank you very much, Mr. Chair. So for NDP 20, this is similar to the last NDP amendment, and this would eliminate Bill C-16's exception to the safety valve for particular offenses, which currently increases the likelihood of charter rights violations, and particularly for racialized people who are overrepresented in the criminal justice system. We cannot pick and choose when it comes to charter rights. We must ensure that they're upheld for everyone. And so I urge that my colleagues to vote in favor of this amendment.
Thank you, Ms. Kwan. Before I hear from anybody else, if NDP 20 is adopted, CPC 25, CPC 25.1, CPC 25.2, and CPC 25.3 cannot be moved due to a line conflict. Ms. Latanzio?
I cannot support this motion because excluding offenses which carry life sentences from the ambit of the proposal judicial discretion was a deliberate choice to reflect the seriousness of these crimes, and therefore the mandatory life sentences and period of parole ineligibility have been upheld by the Supreme Court of Canada. And so for these reasons, I will not be supporting the amendment.
Thank you. Okay, shall NDP 20 carry?
No.
Defeated. Okay. CPC 25. Mr. Brock.
That's mine, Mr. Chair.
Actually, before you get, if CPC 25 is adopted, 25.1, 25.2, 25.3 cannot be moved due to a line conflict.
Correct.
Okay.
Correct. So, folks, I'm mindful of the time. I'm mindful that we are only on page 84 of a 147-page bill. So I'm not going to belabor the point. I believe if I were afforded the opportunity of a fulsome explanation to justify this amendment, I would be repeating myself from this morning and early afternoon. Clearly, I want consideration from all members of this committee to look at serious expansion of offenses that should not ever qualify for any judicial discount from the mandatory minimum penalty. Right now, C-16 only preserves, as we know, murder and treason. I've already spoken at great length about child sexual abuse material, and quite frankly, this particular amendment speaks specifically to any sexual offense against a child, and that is then referenced directly to section 490.011, sub 1 of the code, which provides authority for SOIRA, S-O-I-R-A, Sexual Offender Information Registration Act consideration. There is a whole litany, a whole list of offenses that would fall within the category of primary and secondary offenses. And again, I would highlight, if there is one class of Canadians that we as parliamentarians should be standing firm on, that is protecting our most vulnerable assets. That is our children. And again, the fact that a particular trial judge saw fit to afford Mr. Seneville and Mr. Nod a 45-day weekend sentence should be appalling to all of us. So I would encourage all parliamentarians at this committee to give serious consideration to supporting that amendment. And secondly, I've asked for a reinstatement of essentially mandatory minimum penalties under Section Part 1 of the Controlled Drugs and Substances Act. When we're looking about the opiate crisis, the fentanyl crisis, the fact that the Minister of Justice refuses, for whatever reason, not to reflect the spirit of C-16 and resurrecting all of the offenses that this Liberal government gutted in C-5, I think is an opportunity for a course correction. Again, I'm not repeating myself. I don't want to repeat myself. We all understand and agree that there is a crisis of substantial measures in this country when it comes to trafficking this poisonous substance, importing, exporting, production, and all of that is contained within the amendment, and I would hope my colleagues would give serious consideration to that. Thank you.
Mr. Barber and Ms. Latanzio.
My colleagues understand my point about the safety valve, and that specifically, as I mentioned earlier, the Liberal government decided that murder and treason are going to be specifically excluded from the application of the safety valve. Mr. Housefather suggested that that is because of the seriousness of the offenses and that we're less likely to run into a situation where a court would deviate from the prescribed minimum penalty. But here I am to suggest that, well, first of all, that's not necessarily true. You might think of a situation like Edward Snowden, where public opinion was very much in favor of a defector who was accused of treason and tried in absentia. But I am here to suggest that if we believe that murder and treason are so serious that they rise to the mortal turpitude of being excluded from the safety valve, then here along comes Mr. Brock and says, please exclude serious offenses from the application of the safety valve. Please exclude child sexual offenses from the application of the safety valve. So Nod, when he gets caught with 300 videos of children aged 3 to 6 being raped, is subjected to the mandatory minimum sentence of at least 1 year. 1 year is generous for that monster.
Yes.
That's what we're saying here. Let's work collaboratively to protect children. That's what this amendment is about. Thank you.
Ms. Latanzio.
Thank you, Mr. Chair. So while I can appreciate the interventions of my colleagues, we've seen what happens when we get this wrong, Mr. Chair. So mandatory minimums get struck down, cases get delayed, and in the end, offenders don't face the consequences that they deserve. That doesn't protect victims. It leaves them waiting longer and without the accountability they deserve. This provision is what makes the difference. It allows us to keep serious penalties in place and in a way that will actually hold up in court and apply in real cases. And ultimately, colleagues, this is about protecting victims, especially those affected by serious violence, including intimate partner violence, and making sure the system delivers real accountability. Even the colleagues, as mentioned previously this morning, even the Conservative colleague on the other side, Member Caputo, is in full agreement with the application of the safety valve. And this amendment would completely remove the safety valve. And so I think that judicial discretion is necessary if we want these laws to last. So this isn't, again, about going easy or on anyone. It is about making sure that the law works for the people it is meant to protect. Thanks.
Thank you, Ms. Latanzio. All right, shall CPC 25 carry?
Yes. For the vote?
Mr. Clerk?
On CPC 25, Mr. Chair, Madame Latanzio?
No.
Monsieur Housefather?
No.
Madame Gladue? No. Monsieur Guilbeault?
No.
Madame Khalid?
No.
Mr. Blois?
No.
Mr. Brock?
Conservatives will always protect the vulnerable Canadians. And
Yes
the
or no,
answer-
Mr. Brock?
The answer
Yes or
is
no?
absolutely yes.
Mr. Baber?
Yes.
Mr. Mantle? Mr. Gill?
Yes.
Monsieur Fortin?
No.
Defeated.
Okay, defeated. So CPC 25.1. Again, if adopted, point 2 and point 3 cannot be moved. Mr. Brock, is this you again?
No, it's Mr. Gill.
Mr. Gill? 25.1.
25.1, okay. Thank you, Mr. Chair. And I'm very pleased to move this amendment 25.1, which seeks to expand the safety valve to include mandatory minimum charges under Section 272 of the Criminal Code. Those charges deal with sexual assault with a weapon. The current mandatory minimums in the Criminal Code are 5 years for a first offense and 7 years for reoffenders. When we are talking about protecting victims of intimate partner violence, these mandatory minimum penalties ensure that violent and repeat offenders are kept behind bars. When I asked Jennifer Dunn on April 15th, I quote, "For the sake of the victims, should violent and repeat offenders serve stronger and longer sentences?" She replied, quote, "Absolutely. A violent and repeat offender needs to be held accountable for what they have done. I agree 100%. This amendment ensures that violent and repeat sexual assaulters are held accountable for their crimes. Thank you. And I will encourage everyone to support this one.
Thank you, Mr. Gill. Shall 25.1, CPC 25.1 carry?
Yes.
Mr. Clerk?
Thank you, Mr. Chair. On CPC 25.1, Madame Latanzio?
No.
Monsieur Housefather?
No.
Madame Gladue?
No.
Monsieur Guilbeault?
No.
Madame Khalid?
No.
Mr. Blois?
No.
Mr. Brock?
Yes.
Mr. Baber?
Yes.
Mr. Mantle?
Yes.
Mr. Gill?
Yes.
Mr. Fortin? No. Defeated.
Defeated. Okay, CPC 25.2. Mr. Gill?
Thank you again, Chair. And I'm moving Amendment 25.2 with the hope that we can make our laws tough for criminals, and which seeks to expand again safety valve to include mandatory minimum charges under Section 273 of Criminal Code. Those charges deal with aggravated sexual assault. My riding of Brampton West is located in Peel Region. Peel Region has declared intimate partner violence an epidemic. In 2024, Peel Police responded to over 16,000 incidents of family or intimate partner violence. That's more than 44 incidents a day. We need stronger penalties for violent offenders to keep them off the streets and curb this epidemic. The current mandatory minimums in the criminal codes are 5 years for a first offense and 7 years for reoffenders. We need these violent and repeat offenders to stay behind bars so we can work to cure this epidemic sweeping across my region and in some part of the country. Thank you.
Mr. Baber, and then Ms. Khalid.
I'm just trying to bridge the gap, and I'm trying to understand why there's no consensus in this committee on how we should apply the safety valve. This is a very technical bill. I don't think we're having political disagreements. If we're having a legal disagreement, then let's have a conversation. Let's ask the officials again. Let's get a second opinion. We all want to arrive at the right result. An aggravated sexual assault contemplated in Mr. Gill's amendment is now subjected to a safety valve, according to this legislation, where a judge can disregard the mandatory minimum if he or she find that it's cruel and unusual. I'm saying we're looking at a sentencing stage. In other words, the accused has already been found guilty of an aggravated sexual assault. And either the safety valve is good enough to be excluded from murder and treason, but it's not good enough to be excluded from an aggravated sexual assault. I don't understand that. And if all of this is lost in translation because people have a different idea about how judges might apply the law, let's not rush it and hammer it out. We have an intimate partner violence epidemic, an emergency in Peel Region where Mr. Gill comes from. Let's bind judges to impose the mandatory minimum on aggravated sexual assault. It's so grotesque. And if we're missing each other because we're not certain about how the law will work here, and I think there's legitimate disagreement about what is happening with the safety valve and whether the mandatory minimums are going to be restored, respectfully, I'm not sure that I share the legal opinion of the panel of the officials. Let's work it out. Thank you.
Ms. Khalid and then Ms. Latanzio.
Thank you, Mr. Chair, and where I take the comments of my colleagues. I am from Peel Region as well. Mississauga Erin Mills is the best riding in the country, which I appreciate, and it happens to be part of Peel Region. And Mr. Gill is absolutely right. We do have a significant increase in intimate partner violence over these years. And there have been ways in which we've been trying to deal with that. There is no flip of a switch where you can just say, okay, this law is done, this judge is now, their discretion is taken away, and now all of a sudden we are going to find solutions. What Peel Region has actually done locally is that they've created a safe center where victims and survivors of intimate partner violence are able to go to get that full covered support, whether it is police, whether it's child services, whether it's housing, transitional housing, whatever that support they need. So when we talk about giving discretion or removing discretion from judges, what we are really missing is the fact that a crime that has been committed against an intimate partner doesn't get its justice from that time that there's a conviction or there's a sentencing. The support that a victim and a survivor needs has to start from day one of them having faced that. And that requires all levels of government jumping in and providing the support that that intimate partner and her family and kids will need. You know, we talk about protecting our kids here in this committee. Well, it's not mandatory minimums that are protecting kids. It is the local support, the collaborativeness with all levels of government that is going to help us get there. And taking away judicial discretion is not the way, because what that will ultimately do, in my opinion, is that it will take away the context for why the case is where it is, how things have progressed over the entirety of the entry into the judicial system with the victim and the survivor. And I think taking that context away is going to hurt the victim further, not help them.
Thank you, Ms. Khalid. Ms. Latanzio.
Thank you, Mr. Chair. Giving judges the discretionary power ensures that a judge takes into account the different circumstances of each sentence and does not apply one size fits all. So my question to the officials is the following. Once again, I come back to this, is if we remove this judicial discretion, would that not take away the whole basis of the safety valve that we find in C-16?
Thank you for the question. So excluding Section 273 from the application of the judicial discretion clause would leave those offenses or those MMPs open to constitutional challenge and may have the effect of fewer offenders being subject to those MMPs. This is because it would be excluded from the ambit of the proposed Section 718.4, and they would be potentially subject to constitutional challenge on the basis of reasonable hypothetical scenarios. And then if that MMP is struck down, it cannot be applied to anyone in the jurisdiction in which it's been struck down. Clause 63 would insulate the existing MMPs against constitutional challenge, while also, as we've discussed previously, reviving MMPs that had been previously struck down.
Thanks.
Go ahead, Mr. Brock.
Well, this is becoming a real frustrating exercise, Mr. Chair. I listened to my colleagues' interventions, and I have the utmost respect for my colleague, Ms. Khalid. But this particular amendment doesn't speak to the continuum of criminal justice as it relates to victims of this extremely serious, heinous offense. When we're talking about something that's aggravated in the hierarchy of offenses, we're getting very close to homicide levels. In fact, an aggravated assault, in this case, aggravated sexual assault, really in the hierarchy of offenses is one notch below that of a homicide. That's how serious this House of Commons, Parliament, has decided over several decades to treat this offense. So while I agree with Ms. Khalid, and I'm glad to hear that Mississauga is taking the appropriate steps to ensure wraparound services for victims, this is about restoring justice back into sentencing. And right now, in my view, I'm sure that the officials will agree with me, that sentencing is an art. It's not a mathematical equation. I see some heads shaking, so I'm not going to ask anyone specifically, but we're going to agree with that in principle. And judges already take into consideration the personal circumstances of an offender. But what we don't want to see happening here is for some activist jurist somewhere in Canada, and I'm going to repeat this because it bears repeating, there is no minimal standard by which Canadian judges uniformly sentence on criminal matters in this country. It depends on appointment, it depends on region, it depends on filling quotas. DEI, which should never exist in our judicial appointment process, unfortunately still exists. We want to get back to the point of merit, where it doesn't matter about your orientation. It doesn't matter about your color of skin. It doesn't matter about your religion. It doesn't matter about the legal work that you have contributed to certain underprivileged classes of individuals in your communities. It should be based on legal merit. And I'm actually glad that there are some governments, provincial governments in this country focusing in on a merit-based application. But that means is we have a huge discrepancy when it comes to sentencing. So all we're asking this committee to consider is to give a baseline for consideration when you're dealing with one of the most serious, not one of the most serious form of committing a sexual assault on another human being, is to exclude that from any judicial discretion, so that on the basis of stare decisis, of precedent value for future judges in similar circumstances, we'll know that the mandatory minimum penalty is a threshold that we as parliamentarians set as a base standard. There are going to be cases on the lower end of the spectrum where the minimum penalty is absolutely appropriate. But there's going to be, and I had cases as well, that the mandatory minimum penalty would be woefully inadequate in the circumstances. So all we're asking, again, is that we as parliamentarians give judges the appropriate direction, that we as a supreme entity, it's not judges who make laws, it's we as parliamentarians who make laws and they interpret those laws, that we have established that this is a threshold that we will not deviate from. I think this is a great opportunity for us to take the appropriate stand. Thank you, Chair.
Thanks, Mr. Brock. Mr. Mantle?
Thank you, Mr. Chair. Pleased to speak on this amendment. I think what we're trying to do is identify those crimes that are so heinous that they should be excluded from the safety valve. And I think the Liberal government has put themselves in a pickle here because they have created an arbitrary line to say certain crimes should be excluded, but others shouldn't be. And they have as yet been unable to provide a cogent reason for some of those exclusions. And I think we're offering to them some of the crimes that we would suggest are so heinous that they should be excluded. And the response about fears of a constitutional challenge, which I continue to hear, suggests to me sort of a lack of courage on the other side to take up the responsibility as legislators to make laws. We believe in the supremacy of Parliament and respect the independence of the judiciary. But that is the separation of powers, and abdicating your responsibility to make law because of the fear that you hold of the judiciary is an abdication of your role and an abdication of our constitutional arrangement. And I was perplexed by my colleague from Mississauga's comments, and I'm glad she's speaking on them. This is an issue that affects her area more than others in this particular amendment with respect to aggravated sexual assault. But she suggested in her comments that excluding aggravated sexual assault would somehow harm victims. And I don't follow that logic. So maybe she can explain that in a further intervention. But in my view, putting the bad person in jail will not hurt the victim. Victims, as I understand that, demand justice. And that means removing the offender from society as a means of showing our approbation for that heinous crime and keeping them out of society so that they cannot commit that crime again. So I'm confused by her logic in how doing so will somehow hurt the process or hurt victims. So maybe she could explain that to the committee and to her community.
Thanks, Mr. Baber, and then Mr. Housefather.
Before I return to the amendment, I'd like to respectfully express my concern to the officials and specifically to Ms. Burt. We operate, and by that I mean lawyers, in a very uncertain environment. I used to say, as a litigator, there's no such thing as a slam dunk case. I used to think, you think you have a slam dunk case in commercial or civil litigation? It's probably like 70%. And then you got to split success, and then you got to factor in the costs. And then you walk away, and hopefully you did better than you thought you might. But I am not convinced, Ms. Burt. I say this with the greatest respect. I'm not, Mr. Taylor, I say this with the greatest respect. I do not see how the mandatory minimum sentences are restored by virtue of the safety valve. You may wish that they're restored. You may wish that judges will now say, I have a safety valve, and therefore I'll consider the safety valve, but that applies directly to the case before the justice. It does not apply to the constitutionality of the mandatory minimum penalty. I'm not sure that it does, and I think that we'll have to be cautious. None of this is political. And with my greatest respect to my colleague from Mississauga, Ms. Khalid said that eliminating judicial discretion will not help victims. I hope that I'm quoting her correctly. She said, I'll repeat that for her benefit, eliminating judicial discretion will not help victims. But I have to very respectfully and very strongly disagree with it. I refer her to the basic principles of sentencing. The two primary principles behind sentencing, first is denunciation, so we condemn the conduct, and we express that as a society by condemning aggravated sexual assault. And the second principle, and that is, in my view, the most important principle of sentencing, is deterrence. Deter this specific offender and other and future offenders from committing aggravated sexual assault. And that's what a stiff sentence will do. And that still can account for the individual circumstances. If you stand by your legislation and you introduce a safety valve and you have some sort of absurdity in a situation where a person is convicted of an aggravated sexual assault, then we will put our faith in the court to have an off-ramp, which is what the safety valve is really about. But let's not get to the point where we're claiming absurdity that deterrence by imposing a stiff sentence will not help future or other victims. Thank you.
Mr. Housefather.
Yeah, Mr. Chair, I'll be relatively brief. I think that, as Mr. Baber correctly said, there's a general agreement, at least amongst most members of this committee, that the use of hypotheticals or reasonable hypotheticals created a poor decision in the Sandoval case is something that we want to eliminate as a variable to have the court keep striking down minimum mandatory sentences that Parliament adopts. And as a result, we've arrived at a situation where we have a suggestion in C16 that is a safety valve that I think is a very good suggestion because it prevents the use of reasonable hypotheticals to strike down sentences or minimum mandatory sentences for a class. And it may lead to one decision on one offender that is problematic in certain cases, but it will not lead to the whole class being thus exempt from minimum mandatory sentences. Then we get to the points that, and I understand, I think it's everybody is reasonable in this with where they come from. The way the legislation now works, and I think it's a reasonable way to deal with it, is life sentences where the minimum mandatory sentence is life. Then the reasonable hypothetical is so unlikely to ever be used to strike anything down, and it hasn't been by the courts, that we're saying these sentences are the highest because they're the most serious of crimes, and so we will not allow judges' discretion on those. But everything that is not a minimum life sentence, we're allowing, the safety valve to apply. And the Conservatives reasonably are saying, but for this sentence or for this sentence, for this sentence, we don't think that should be. So the line is here, the line could be there, different people will have different lines. And different people will take charter risk and say, I accept this level of charter risk or I accept this level of charter risk in order to have. So I think we're all, again, in agreement on a concept. And like you said, we're in a different place under the line that we're choosing to take on this. I think we're all here in good faith, and I'm going to be voting against this amendment because I'm comfortable with the minimum life being the line and where the threshold and where the charter risk will be if you start adding one. And also the variables, right? If I add, there are many heinous crimes that don't have a minimum life. And if I take one, why am I not taking another one? So it's always then the line gets more blurry or more blurry. You might say it's any sentence that's 20 years or any sentence that's 15 years or 10 years or 14 years, but it's difficult. So again, I get it. I respect my colleagues where, and where they're coming from on this, but I'm going to vote against this one.
Thank you, Ms. Collin.
Chair, I just want to address a couple of the things that my colleagues have pointedly said. about my remarks, and I stand by it. There is no solution to intimate partner violence without wraparound service in communities like Mississauga and Peel and all across our country. Now, my colleagues have been talking about how judges should not be able to present or use reasonable hypotheticals in their decisions that they would make, as we've discussed earlier. And yet, I have spent a very, very long time listening to them present hypotheticals as legislators to decide as to why certain things should be or should not be moved in a bill, such as this one. C-16's intent is to provide safety and security to women to combat intimate partner violence. And when, Mr. Brock, for example, and I have the utmost respect for Mr. Brock, but when he talks about the context of diversity, equity, inclusion not being necessary in sentencing, not being necessary in finding a solution to XYZ, I do take exception to that because I do think that it is necessary. I do think that context matters. What happens in an urban city like Mississauga is very, very different from what happens in rural Quebec, for example. And I think that judges need to be able to look at a situation and work from there. And I trust the jurisprudence. I have full faith in the justice system in our country. Yes, we can obviously make it better, but not by overstepping the bounds and not by imposing our hypotheticals onto them as they try to take in and make just decisions and set jurisprudence that defines how laws are interpreted within our country. Absolutely, we write the laws, sure, but that interpretation matters. And that interpretation is different from different parts of the country, and as it should be. I mean, there's a reason why in our country there's a separation between all the different branches of government. And it is to secure fairness, is to ensure that communities are safe, not just, that we're rehabilitating communities, not just punishing and just putting and holding everybody to account at the same level when we should be being nimble and allowing our justices and judges to have that discretion to be able to apply the law as is just. I'll stop there, Mr. Chair. Thank you.
Thanks, Ms. Collett. Is this a new point, Mr. Barber? Okay, go ahead.
With respect to my friend, Mr. Housefather, he said, I'm sort of feeling out the line and I'm comfortable with the line being here or perhaps not here, but over here I'm fairly comfortable. What in effect Mr. Housefather is suggesting is an arbitrary line. And I think he's nodding in agreement. And I'm glad we agree on this point, because we should not be drawing an arbitrary line when it comes to sentencing. We have enough faith in the judges to exercise discretion. No one's taking away that discretion. The safety valve adds it, as you say. But I can't believe that somehow we would now here apply a line of turpitude, of the guilty mind, where we say, on this guilty mind, we throw the book on you. But at this guilty mind, you can have an off-ramp without looking at the specific circumstances of the case. An aggravated sexual assault is an aggravated sexual assault. I don't even want to describe the elements of that case. Applying this arbitrary approach in our respectful suggestion is incorrect. To Ms. Khalid, we are well within our right to use hypotheticals because we make the law, for better or for worse, and judges apply them. That's our entire job description. And for better or for worse, Parliament is supreme. And we get to write the statute and judges get to apply it. We should not shy away from that duty. We should embrace that. And most importantly, no one is saying that somehow stiff sentencing can eliminate the need for wraparound services or rehabilitation. Of course, rehabilitation is another very important component of all of this. All I'm saying is, let's not forget the most important principle of sentencing, and that is deterrence. And if we here, sitting here, if we have the opportunity to deter aggravated sexual assault in Peel, and we don't avail ourselves of that, then I think we failed in our duty as legislators. Thank you.
Mr. Brock.
Yeah, very briefly to the officials. Without holding you to the actual decision itself, the general theme, would you agree with me, in sentencing in this country for a number of serious offenses, particularly aggravated sexual assault, is you don't talk about rehabilitation. You talk about denunciation, you talk about removal from society, and you talk about deterrence as being the primary sentencing factors. Yes or no?
Thanks for the question. Certainly, the Supreme Court has emphasized the more serious the offense, the more the emphasis on those types of sentencing principles, without necessarily excluding some of the others. But you are correct, Mr. Brock. There is a greater focus on denunciation in those situations.
Thanks, Mr. Brock. Okay, shall CPC 25.2 carry?
Yes.
Mr. Clerk.
Thank you. Thank you, Mr. Chair. On CPC 25.2, Madame Latanzio?
No.
Monsieur Hausfader? Madame Gladue? No. Monsieur Guilbeault?
No.
Madame Khalid?
No.
Monsieur Saini?
No.
Mr. Brock?
Yes.
Mr. Baber?
Yes.
Mr. Mantoul?
Yes.
Mr. Gill?
Yes.
Monsieur Fortin?
No.
4-7 defeated.
Defeated. Okay. CPC 25.3. Mr. Gill, okay.
Thank you, Chair, again. And I would like to move Amendment CPC 25.3 that Bill C-16 in Clause 63 be amended by replacing line 9 on page 71 with the following: meant for life or to an offense under Section 346, which seeks to expand the safety valve to include mandatory minimum charges under Section 346 of the Criminal Code. This section deals with extortion and carries a mandatory minimum of 5 years for first offenses and 7 years for reoffenders for extortionists who use firearms. Communities like Brampton and Surrey are dealing with massive increase in extortion over the last 5 years. Business owners and families are living in fear. People are fearing for their lives. Extortionists are so unafraid of getting caught that they are filming themselves firing guns at homes in Brampton. We will never stop these extortions with weak penalties that will have them right back out on the streets and back to threatening families. We need strong and long sentences to keep these violence criminals behind bars where they belong. And I would like to say, I spoke about extortion and crime happening in the neighborhoods and on our streets many times. And this is something I am receiving every week. A Riding resident or a Brampton resident is calling me and expressing their concern regarding this extortion, that they keep getting demands for the money from these extortionists. I always say that crime is non-partisan issue, and we all are here to make our communities safer and stronger. We as a parliamentarian are here to make our laws robust so that these criminals cannot get benefit out of it. In my opinion, putting the repeat violent offenders behind the bars will help victims and create confidence among Canadians and restore justice for the victims. Thank you.
Thank you, Mr. Gill. Okay, shall CPC 25.3 carry?
Yes.
Mr. Clerk.
Thank you, Mr. Chair. On CPC 25.3, Madame Natanzio?
No.
Monsieur Housefather?
No.
Madame Gladu?
No.
Monsieur Guilbeault?
No.
Madame Khalid?
No.
Mr. Saini?
No.
Mr. Brock?
Yes.
Mr. Baber?
Yes.
Mr. Mento?
Yes.
Mr. Gill?
Yes.
Monsieur Fortin?
No.
4-7.
Defeated. Okay, so clause 63 will have to defer because of our deferral on CPC 23, which takes us to clause 64. Shall clause 64 carry? Yes. Carried. Shall 65 carry? Yes. Carried. Shall clause 66 carry? Yes. Shall clause 67 carry? Yes. Carried. Okay, clause 68 takes us to NDP 21. Ms. Kwan.
Thank you very much, Mr. Chair. On NDP 21, as with the previous NDP amendments, this would extend protections in legal proceedings to all those victimized by intimate partners and not those of a limited number of offenses. Mr. Chair.
Thank you, Ms. Kwan. Anybody else? No. Okay. Shall NDP 21 carry? No. Defeated. Okay. Shall clause 68 carry? Yes. Carried. Clause 69, NDP 22. Ms. Kwan, back to you. If NDP 22 is adopted, G32 cannot be moved due to a line conflict. Ms. Kwan?
Thank you, Mr. Chair. So again, similar to previous NDP amendments, this would extend protections in legal proceedings to all those victimized by their intimate partners, not restricting protections for a limited number of offenses. Echoing the recommendations of the National Association of Women in the Law, New Democrats are committed to ensuring survivors of intimate partner abuse of all forms are protected while testifying in court, and we urge all parties to vote in favor of this amendment to ensure these protections are in place.
Thank you, Ms. Kwan. Mr. Brock and then Mr. Barber.
I don't have the actual bill in front of me, but to the officials, is this within the context of sentencing only, or would it apply at the judicial interim release stage as well to include all offenses that pertain to an intimate partner?
Thank you for the question. Thank you for the question. This is a sentencing provision, so it's a new provision in the criminal code that would allow a judge to impose an order prohibiting an offender when they're being sentenced from contacting a victim or witness or another person when they're being sentenced for certain offenses.
This is not mandatory. This would be a discretionary order.
That's correct.
Now, do you not think this particular clause would be redundant? I'm just thinking about the number of times I was prosecuting, say, a non-assault offense involving a husband or a wife or a boyfriend, girlfriend. It could be mischief. It could be a break and enter. It could be a number of other non-assaultive offenses. And I would routinely be asking for a no contact order as part of probation, and 9 times out of 10, it would be granted. So in the context of currently what's happening in our judicial system with that discretion already being available to judges, and where crowns ask or where victims ask specifically for that type of protection in their victim impact statement, don't you think that the current regime already addresses the concerns raised by my NDP colleague?
Thank you for the question. This no contact order fills a gap in no contact orders, so it allows the order to be in place for life, which isn't currently available. I believe that what the NDP motion is proposing is to change the scope of offenses for which the no contact order can be imposed. So what's proposed in Bill C-16 is to allow for it to be the no contact order to be imposed in cases of certain listed offenses, and including offenses in which violence is used, attempted, or threatened against an intimate partner. And the proposal is to have it apply to any offense against an intimate partner.
Thanks for the clarification for follow-up purposes. So C16 talks about a no-contact order for life in those circumstances?
This what's proposed in this clause, yes.
Okay,
It can be for life or for a shorter period of
I
time.
missed that distinction, so
Yep.
thanks for pointing that out.
Okay.
Brock. Shall NDP,
One second.
oh, sorry, Mr. Barber, yeah.
Okay,
believe I
as
forgot
far
you.
as I understand, what NDP 21 does, it expands the scope of when a judge may impose a no-contact order to include all offenses against an intimate partner. Am I correct?
Yes, that's right.
Okay, well, this NDP amendment actually makes a lot of sense to me. I don't think it should be overly contentious, and I believe that we'll vote in favor of it. Thank you.
Conservatives will.
Thank you. Okay, shall NDP 22 carry?
Yes.
Okay, Mr. Clerk.
Recorded vote. Okay. Thank you, Mr. Chair. On vote on NDP 22, Madame Latanzio? Monsieur Housefather? No. Madame Gladu?
No.
Monsieur Guilbeault? Madame Kalin? Mr. Saini? Mr. Brock?
We can stand by
All right, we're voting, people. It's yes or no,
Mr.
not
Brock?
conversation time.
Absolutely, I support this.
Mr. Baber?
Yes.
Mr. Mantle?
Yes.
Mr. Gill?
Yes.
Monsieur Fortin?
No.
Defeated.
Defeated. Okay, takes us to G32. Ms. Latanzio, was this you? Okay.
Thank you, Mr. Chair. So precisely, we voted down NDP 22 to be able to introduce G32. The purpose of this motion is to expand the availability of the bill's proposed no-contact orders to apply to offenders who commit any offense against their intimate partner and not just a violent offense. And in so doing, it provides greater protection to victims and recognizes that non-violent offenses can involve elements of power, control, and psychological abuse when committed in the context of an intimate partner relationship. And that is why we voted down NDP 22. Thank you.
No other hands? Okay. Shall G32 carry? Yes. Carried. Okay. Shall clause 69 as amended carry? Yes. Shall clause 70 carry? Yes. Shall 71 carry? Yes. Okay. Shall 72 carry? Yes. Shall 73 carry? Yes. Okay. Clause 74, G33. Ms. Khalid.
It's a technical amendment. It corrects a typo in the bill.
Thank you. Shall G33 carry?
Yes.
Carried. Shall clause 74 as amended carry? Yes. Carried. Shall 75 carry? Yes. Shall 76 carry? Yes. Shall clause 77 carry? Yes. Carried. Shall clause 78 carry? Yes. Shall clause carried. Shall clause 79 carry? Yes. Carried. Clause 80, Mr. Fortin, over to you for BQ1.
Merci, Monsieur le Président.
Thank you, Mr. Chair. So BQ1 and BQ2 simply want to align the text. We did past amendments related to the objective test versus the subjective test. So it's just a question of alignment. I think that in the affected clauses, the same criteria need to apply. So 810 and 810.1. And I'm not too sure which article. I think it's 370 something. So it's just about alignment.
Thank you, Mr. Fortin. So BQ1 carry? Defeated. Shall clause 80 carry? Yes. Carried. Okay, clause 81, BQ2, Mr. Fortin.
Même chose, Monsieur le Président.
Same thing, Mr. Chair. It's a question of alignment. So 8101 when it comes to the reasonability.
Okay, shall BQ2 carry? No. Defeated. NDP 23, Ms. Kwan.
Thank you very much, Mr. Chair. So this amendment reflects a suggestion from the National Association of Women in the Law to strengthen language in this bill around weapons prohibitions as a condition for reconnaissance for offenders in intimate partner violence cases. Experts from the National Association of Women in the Law have told us that it is essential to close loopholes in the Firearms Act that continue to endanger survivors of intimate partner violence. I urge my colleagues to support this amendment in protection of women and gender diverse people from gun violence.
Thank you. Shall NDP 23 carry? Mr. Clerk.
Okay. Thank you, Mr. Chair. On NDP 23, Madame Latanzio?
No.
Monsieur Housefather?
No.
Madame Gladu?
No.
Monsieur Guilbeault?
No.
Madame Khalid?
No.
Mr. Saini?
No.
Mr. Brock?
No.
Mr. Weber?
No.
Mr. Mantle?
No.
Mr. Gill?
No.
Monsieur Fortin?
Oui.
1-9.
Okay, defeated. Shall clause 81 carry? Yes. Yes. Okay, so I can bunch clauses 82 through 89 since there are no amendments proposed. Shall clauses 82 through and including 89 carry? Yes. Thank you. Okay, which takes us to clause 90. PV1 is withdrawn. So shall clause 90 carry? Yes. Carried. Shall clause 91, PV8 is withdrawn.
Someone looking for their lost
That was a lost phone and the person's looking for it. So,
So we could actually go to
we got to do.
to 102.
Okay, so PV drawn, which means I can group clause 91 through to,
102.
no, 99.
Oh, yes, 99.
Yeah. So, okay, just so everybody's on board here, I don't want to miss anybody. Shall clause 91 through to and including clause 99 carry? Yes. Carried. Okay, clause 100 brings us to G34. Ms. Gladu.
Thank you, Chair. This is a technical amendment. Essentially, Clause 100 applies to Clauses 31, 32, and 34, but right now the reference to Clause 32 is missing, so it will fix that.
Shall G34 carry? Yes. Carried. Shall Clause 100 as amended carry? Yes. Shall Clause 101 carry? Yes. Carried. Shall Clause 102 carry? Yes. Carried. New Clause 102.1 takes us to NDP 24. NDP 24 refers to Clause 40.1, which was created by NDP 17.1. If NDP 17 is not adopted, the opposite. Okay, remind me what happened. What did we do with NDP 17? Okay, NDP 24, Ms. Kwan.
Thank you very much, Mr. Chair. This amendment would create a for greater clarity clause so that measures surrounding procedural protections for victims come into force on the same day as the bill.
Sorry, I read that backwards, yeah. Sorry. 17 was not adopted, right?
That's right.
Or may create an inquiry. So anybody else on NDP 24? No? Shall NDP 24 carry? No. Defeated. Okay.
So 103 to 118.
Okay, shall clause 103 through to and including clause 118 carry? Yes. Thank you. Okay, new clause 118.1 takes us to G35. Ms. Latanzio.
Thank you, Mr. Chair. So this motion would require a review of the bill's proposed course of control of intimate partner violence 5 years after the bill would receive its royal assent. This new clause would require the review to include consideration of criminalizing coercive control in relationships other than intimate partners in intimate partner relationships, thus allowing the time for law enforcement to be trained on the existing offense before expanding the application of coercive control laws. This incremental approach is consistent with the fact that some are taken, some of the other jurisdictions into account, and they've enacted coercive control offenses because it allows time for study and training for law enforcement, both of which have been critical to ensuring implementation of the offense consistent with its important objective, always of protecting victims.
Thank you, Ms. Tanzio. Okay, shall G35 carry?
Yes?
Carried. NDP 24.1, Ms. Kwan.
Thank you, Mr. Chair. The legal experts and civil liberty groups from across Canada have raised strong concerns about the implications of Clause 46. That includes the Canadian Civil Liberties Association, the David Asper Centre for Constitutional Rights, the Criminal Lawyers Association of Ontario, Barreau du Quebec, the Women's Legal Education and Action Fund, and the Canadian Bar Association. This clause would violate the Supreme Court decision in Regina versus Rahi that clearly determined a stay is the minimum remedy for a Section 11B charter violation. As currently drafted, Bill C-16 sets a precedent where the government can decide what the remedy is for a charter violation and overrule a Supreme Court of Canada's decision in doing so. This is a threat to our Constitution and to our democracy, where the government itself dictates the consequences, if any, for its violations of charter rights. The most recent comprehensive parliamentary study on trial delay in Canada, the 2017 report by the Senate Standing Committee on Legal and Constitutional Affairs, explicitly recommended the Minister of Justice seek a reference from the Supreme Court on any proposed changes to the remedy for Section 11B to ensure that they would be constitutional, which is what this amendment would require of the minister. If the government is confident that this legislation is constitutionally valid, it should have no problem accepting this NDP amendment to Bill C-16.
Thank you, Ms. Kwan. No other comments? Shall NDP 24.1 carry? No. Defeated. Okay, Clause 119. Shall Clause 119 carry? I ask that because all of the Green Party amendments were withdrawn. Yes. Carried. Okay, so new Clause 119.1 takes us to CPC 26, I beg your pardon, which I have reviewed and am ruling out of scope. Mr. Clerk?
Thank you, Mr. Chair. On the question, shall the chair's ruling be sustained? Madame Latanzio.
Yes.
Monsieur Housefather.
Oui.
Madame Gladu.
Yes.
Monsieur Guilbeault.
Oui.
Madame Khalid.
Yes.
Mr. Saini.
Yes.
Monsieur Brock.
No.
Mr. Baber.
No.
Mr. Mantle.
No.
Mr. Gill.
No.
Monsieur Fortin.
Oui.
Merci.
Thank you.
Sustained.
Ruling up sustained. Which takes us to CPC 27, which I have also ruled out of scope.
Challenge.
Clerk?
On the question, shall the chair's ruling be sustained? On CPC 27, Madame Latanzio.
Yes.
Monsieur Housefather.
Yes.
Madame Gladu.
Oui.
Monsieur Guilbeault. Madame Khalid. Mr. Saini.
Yes.
Mr. Brock.
No.
Mr. Baber.
No.
Mr. Mantle.
No.
Mr. Gill.
No.
Monsieur Fortin.
Oui.
Sustained.
Thank you. All members at the table, please. Thank you. Which takes us to CPC 28, which I've also reviewed and reviewed out of scope.
Challenge, please.
On, shall the chair's ruling be sustained on CPC 28? Madame Latanzio.
Yes.
Monsieur Housefather.
Yes.
Madame Gladu.
Oui.
Monsieur Guilbeault.
Oui.
Madame Khalid.
Yes.
Monsieur Saini.
Yes.
Mr. Brock.
No.
Mr. Baber.
No.
Mr. Mantle.
No.
Mr. Gill.
No.
Monsieur Fortin.
Oui.
Sustained.
Thank you. Okay, so there's no amendments proposed for the following. So shall clauses 120 through to and including clause 139 carry? Yes. Thank you. Carried. Clause 140 takes us to CPC 29.
Thank you, Chair. I would like to move this amendment. Mr. Lawton for writing this. I would like to thank my colleague as well for writing this amendment, Mr. Lawton. And I would also like to thank London Police Chief Trong, who supported this idea when he appeared before our committee. CPC 29 seeks to protect victims of intimate partner violence and coercive control. If adopted, this amendment will require victims of intimate partner violence and coercive control to be notified when their abuser is granted a release, a temporary absence, conditional release, or parole. It is common sense that victims must be notified when their abuser is back out on the streets. They deserve to know that the person who hurts or abused them is free and potentially capable to reoffend. Mr. Chair, I know that all the members of this committee from all the parties believe in supporting and protecting victims. This amendment is critical and to ensuring the safety of victims. I urge all members to support the victims and support this amendment. Thank you.
Thank you, Mr. Gill. Any other comments? No. Okay. Shall CPC 29 carry?
Yes.
Okay. Recorded vote.
On CPC 29, Madame Natenzio?
No.
Monsieur Housefather?
No.
Madame Gladu?
No.
Monsieur Guilbeault?
No.
Madame Khalid?
No.
Monsieur Saini?
No.
Mr. Brock?
Yes.
Mr. Baber?
Yes.
Mr. Mantle?
Yes.
Mr. Gill?
Yes.
Monsieur Fortin?
Oui.
5-6.
Defeated. Shall clause 140 carry?
Yes.
Carried. Okay, clause 141 takes us to G36, which is Ms. Latanzio, okay?
Thank you, Mr. Chair. So this motion proposes to amend Section 8.1 of the Canadian Victims' Bill of Rights in Clause 141 to ensure that the proposed list of federal departments, agencies, and bodies from which victims have the right to receive information is recognized as a non-exhaustive list. One of the ways in which Bill C-16 proposes to improve the enforcement of victim rights is to name federal departments, bodies, and agencies that have a role to play in ensuring victim rights are respected. Proposed Section 8.1 is intended to provide a non-exhaustive list of key federal departments and bodies responsible for ensuring that victims receive the information set out in Sections 6 to 8 of the Canadian Victims' Bill of Rights.
Mr. Brock?
Well, yes, I'm fully supportive of empowering victims, and as legislators, we have that obligation to them. And I point out both Ms. Khalid and Ms. Gladu, both have been on status of women, and they've heard from numerous victims themselves and numerous advocacy groups, including the Ombudsman for Victims, about the current lack of available information routes to victims. So any opportunity to expand upon that is welcomed by the Conservatives. I flag this in terms of my intervention, not for that reason specifically, but to also address the potential line conflict with CPC 30, where I was asking for consideration of adding both CBSA and Justice Canada to the listed federal entities for victim right information obligations. You're supporting that? I'm just wondering if it's redundant if you're saying in CPC or G36 that the list is non-exhaustive.
Ours, because we're going to
Including?
be supporting that one. We're supporting that amendment.
Let's do that then.
You want to include the words of CBSA and the Department of Justice in
Yes.
this one?
Yes.
Sure.
Okay.
A sub-amendment to yours, then, is that what we're doing?
Yep.
Do we have the exact language?
Wanna-
Let's suspend. Let's
Okay, yeah.
suspend. Nobody leave the room, please. In fact, nobody go beyond the end of the table. Thank you. We'll suspend.
Still on G36.
We're still on G36.
I have no further interventions. We're
Okay.
supporting.
Thank you. All right, shall G36 carry?
Yes.
Carried. So that takes us to CPC 30.
I'm moving.
Okay, moved. Okay, shall CPC 30 carry?
Yes.
Carried. All right. Shall clause 141 as amended carry?
Yes.
Shall clause 142 carry?
Yes.
New clause 142.1 takes us to NDP 25. Ms. Kwan? Oh, she's gone. Oh. It's deemed moved.
Yeah, we can just vote on it.
Did she leave deliberately? Did she leave intentionally?
Yeah, she had to leave. She sent JF a message. So they're deemed moved. Anyone can ask a question or you can vote.
Okay, so NDP 25 is deemed moved. Does anybody have any comment? No? Okay, shall NDP 25 carry? Defeated. Shall clause 143 carry?
Yes.
Okay. New clause 143.1 takes us to CPC 31. Mr. Brock.
Yes, so the origin of this amendment comes directly from the Office of the Federal Ombudsperson for Victims of Crime, who did testify during your absence, Chair. And specifically, the thrust of his submissions to committee was that currently the Victim Bill of Rights are not legally enforceable due to sections 27 to 29. As drafted, section 27 says as follows: nothing in this act is to be construed as granting to or removing from any victim or any individual acting on behalf of a victim the status of party, intervener, or observer in any proceedings. And his commentary given in testimony was, with respect to clause 27, victims are denied standing, the legal recognition to appear or participate in proceedings. This means they cannot bring a lawsuit or intervene in a case to assert their rights. Section 28, no cause of action. No cause of action or right to damages arises from an infringement or denial of a right under this act. His commentary was a cause of action creates legal liability for an act or omission. Without it, victims have no remedy if their rights are violated. No way to challenge mistreatment, seek a court order to, or claim damages. Section 29, no appeal. No appeal lies from any decision or order solely on the grounds that a right under this act has been infringed or denied. His commentary, if a victim's rights are denied by a decision of a criminal justice professional or order of a court, there is no way to appeal that decision based on the CVBR rights alone. The impact of these clauses, 27 through 29, these three clauses are widely recognized as rendering the CVBR symbolic rather than enforceable. Without enforcement mechanisms, there are few legal opportunities to clarify or expand victims' rights through case law. And I'm sure that, maybe with the exception of some members on the Liberal team currently, we've all probably taken meetings over the last several years from the Federal Ombudsperson for Victims of Crime. I know I have since being elected in September of 2021, and this has been a long-standing concern that he has been advocating for. He has been speaking to the Liberal government. These requests have largely fallen on deaf ears. He has appeared at numerous committees, repeating the same language, asking for enforceable rights. Victims are asking for enforceable rights. And for the life of me, I can't imagine why Ms. Gladue and Ms. Khalid, being former members of the status of women, would actually not seek to expand victim rights. That's my intervention. Thank you, Chair.
Thank you, Mr. Brock. Ms. Latanzio.
I have a question for the officials. So my colleague has just proposed his amendment, and my question to you is, he says it repeals section 27 to 29 of the Canadian Victim Bill of Rights. In your opinion, does it actually create these enforceable rights, and are there any concerns with which the members need to consider before making a decision?
I think that it's not possible to predict with certainty what the effect of repealing those provisions would be, but there are some legal principles that we can turn to figure out what impact that might have. So I think the starting point would be, what did these provisions do when they were enacted? So the intention behind sections 27 to 29 was to state that nothing in the CVBR either granted or took away from victims any standing or any rights to bring actions that they had beforehand. So it didn't create any new causes of action, and it didn't extinguish any. So, yes?
But my question was more, so by repealing them, are we guaranteed that there's going to be enforceable rights? Okay, sorry.
That's okay. So if that's the starting point, then we have to look at where the causes of action would come from. So if it didn't create any new causes of action, but it didn't extinguish any, what are the causes of action? So a civil cause of action can come from an existing tort at common law, or it can be in statute, or it can be in the Quebec Civil Code. So if for example, if Section 28 were to be repealed and there was no express wording creating a cause of action for an infringement of a right under the CVBR, it seems unlikely that repealing Section 28 alone would create a cause of action. So I think the unintended consequence possibly of repealing those provisions is to create the impression that something is going to happen, which may not. It's not known how courts will interpret the repeal of those provisions. It may be that it has an impact on causes of action, but it will certainly create the impression that something is happening, and victims may have their expectations raised, and it may lead to dissatisfaction.
Thank you.
Hands going up. I'll call it a tie. So I'll go Mr. Brock and then Ms. Gladue.
To Ms. Seguin, I don't know if I'm pronouncing your name correctly or incorrectly. I apologize. There's no offense, please. I'm looking at the briefing note I received from the federal ombudsperson, and I listened to what you had to say about causes and the avenues to seek redress. His commentary is victims should have the right to seek judicial or administrative review when their statutory rights are disregarded, just as other participants in the justice system can challenge unlawful decisions. Would you agree with that statement?
I think the criminal justice system is a two-party adversarial system, and with some limited exceptions, victims do not have standing in the criminal justice process. So that would be a fundamental change to the current system.
To change is to give victims status, to give victims standing.
I understand that, and my response is that it would be a fundamental change to the criminal justice system that we have right now.
Okay? And where's the problem in that? You talked about unintended consequences.
I think when I was speaking
What is the danger in giving victims more rights in this process?
The unintended consequences I was speaking of were if it was intended to create a cause of action by repealing Section 28 and it didn't have that effect, that victims would be expecting one thing but receiving a different result.
Okay.
Thank you, Mr. Brock. Ms. Gladue.
Thank you, Chair. I want to be clear that I want to have victims' rights be enforceable, but I don't believe that this particular amendment accomplishes that. Thank you.
Thank you. Okay, seeing no other hands, shall CPC 31 carry?
Yes.
Mr. Clerk.
Yes, thank you, Mr. Chair. On CPC 31, Madame Latanzio?
No.
Mr. Hausfather?
No.
Madame Gladue?
No.
Monsieur Guilbeault?
No.
Madame Khalid?
No.
Mr. Saini?
No.
Mr. Brock?
Yes.
Mr. Baber?
Yes.
Mr. Manto?
Yes.
Mr. Gill?
Yes.
Mr. Fortin?
No.
4, 7.
Defeated. Shall clause 144 carry? Carried. Takes us to clause 145 and NDP 26. Ms. Kwan is not here. It's deemed moved. No comments. Any, shall NDP 26 carry? No. Defeated. Shall clauses 145, can I do this? Yeah. 145 through to and including 154 carry? Yes. Carried. Takes us to clause 155 and G37.
Mr. Chair, Mr. Chair, this is a technical amendment. The motion would expand the application of the sexual activity evidence regime, which prohibits the use of evidence regarding a complaint's past sexual activity to support the, quote, twin myths. Example, that the complainant was more likely to have consented to the sexual activity at issue, or that they are less worthy of belief in sexual offense trials to cases involving an offense under any act of Parliament that is of sexual nature or committed for a sexual purpose and not just a criminal code offense that is of sexual nature or committed for sexual purpose. This motion would align the National Defense Act and the Criminal Code as contemplated by motion G8 to amend clause 3.1.
Thank you, Ms. Latanzio. Mr. Brock?
To the officials, if this amendment were to pass, how, if any, would this impact Bill C-11?
There would be no impact in relation to Bill C-11. This creates a regime within the National Defense Act. Bill C-11 specifically, as tabled, dealt with the jurisdiction over criminal code sexual offenses that were committed in Canada. It does not deal with those offenses that would happen outside of Canada. Therefore, there is still the potential that criminal code sexual offenses will be prosecuted in the military justice system, hence the reason why this entire regime is within the National Defense Act.
Okay, thank you.
Shall G37 carry? Yes. Carried. G38. Ms. Gladue.
Thank you, Chair. This is a technical amendment as well. It inserts a pinpoint reference to section 180.003, which was accidentally omitted. Thank you.
Okay, shall G38 carry? Yes. Carried. G39.
Thank you, Mr. Chair. This is also a technical amendment. It's similar to the G10 that I had proposed earlier, and this one will align the National Defense Act with the criminal code as we had aligned it in G10. It's to clarify that the admissibility of evidence of sexual inactivity must be determined under the sexual history evidence admissibility regime, which codifies R versus Kinnamore.
Thank you, Mr. Housefather. Mr. Brock.
Can I make a suggestion?
You can.
That with respect to G39, 39.1, G40, G41, no objections at all from the Conservatives. We don't need any further explanation. Just move it.
Mr. Fortin, are you in agreement? Yes. Okay. So, shall G39, G39.1, G40, G41 carry? Yes. Thank you. Thank you, Mr. Brock. Okay, it takes us to NDP 27, deemed moved. I see no hands. Shall NDP 27 carry? Yes. Carried. I bet you wasn't here to see that. G42.
Mr. Chair, this is a technical amendment. Once again, this motion would expand the application for the same reasons of the previous, the explanation furnished for the previous amendment that I read out into the record, the exact same rationale.
G42 carry?
Yes.
Carried. G43.
Rationale for G42 would be applicable to G43.
Thank you. Shall G43 carry?
Yes.
Carried. G44. Ms. Gladue.
Yes, this is just the same linguistic technical amendment as before, where it replaces the word disclose with they may produce the listed records.
Okay. Shall G44 carry? Yes. Okay, can I just make a suggestion? You don't have to listen to me if you don't want, but if they're just technical amendments, just move it, and if somebody wants clarification, okay. So G45.
G45, G46, G46.1, G47, deemed to be moved.
Mr. Fortin, you're in agreement with that? Okay, shall G45, G46, G46.1, and G47 carry? Yes. Carried, thank you. Okay, shall clause 155 carry? Yes. Correct, as amended, thank you. Thank you. Seeing if somebody's listening, that's all. Clause 156 takes us to NDP 28, which is deemed moved. Shall NDP 28 carry?
No.
No, defeated. PV1 is withdrawn. So shall clause 156 carry? No. No, okay. Defeated. Clause 157, NDP 29 deemed moved. If NDP 29 is adopted, G48 cannot be moved due to a line conflict. Shall NDP 29 carry? 157. Yeah.
Yes.
No, we're on NDP.
No, we're in clause 120. Hold on.
Yeah, but hold on a minute. Did you call out the vote for clause 157, Mr. Chair? No. Okay.
No.
We're on NDP 29 before.
Okay. All right.
We are on clause 157 now.
Okay.
And NDP 29 is deemed moved.
I got you. Right.
Yeah. So shall NDP 29 carry?
No.
No. Okay. Thank you. So it takes us to G48. Shall G48 carry? Yes. Carried. Okay. Shall clause 157 as amended carry? Okay. All right. Great. All right. See, we're moving so quickly, people can't keep up, which is not a bad problem to have, looking at the clock, I might add. Clause 158, NDP 30, deemed moved. Shall NDP 30 carry? No. Okay, that takes us to G49. Shall G49 carry? Yes. Carried, okay. Shall clause 158 as amended carry? Yes. Carried. Okay, so takes us to clause 159, and then NDP 31 deemed moved. Shall NDP 31 carry? No. Defeated. Shall, okay, G50? Deemed moved. Deemed moved. Shall G50 carry? Yes. Carried. Okay, shall clauses 159 through to and including clause... Correct, thank you. Okay, shall clause 159 carry as amended? Yes. Yes. Carried. Shall clause 160 through to and including clause 164 carry? Yes. Carried, thank you. Okay, clause 165, NDP 32.
G50.1. Sorry, that's my fault. I forgot to add it on your copy.
Oh.
It's the new one, G50.1.
I don't have this one. Okay. G50.1 in clause 165. Okay, shall G50.1 carry? Carried, okay.
Non, mais qu'est-ce qu'on a fait avec NPD 30?
What did we do with NDP 32? It's just before G51. Did you name it? You said 50.1. It's the next one. We're at 50.1. I don't have it.
Okay.
NDP 32.
Right, okay. No, okay, yeah, clause 165 now. Well, hold on. Now you've thrown me off here.
Sorry about that. So this is the one that was missing from your copy.
Okay.
So we're still in clause 165.
What did we do? 164 is done, okay, so NDP 32 was defeated, right?
We haven't voted on this one yet. NDP 32.
Okay, shall NDP 32 carry? No, okay, thank you. Shall, okay, G51? Shall G51 carry? Yes. Carried, and then 51.1?
No,
That was 50.1,
yeah, so
sorry.
clause 165.
Okay, so now we're on, shall clause 165 as amended carry? Yes. Okay. Shall clauses 166 through to and including 169 carry? Yes. Thank you. Okay, clause 170 takes us to G52. Moved. Shall G52 carry? Yes. Carried. Shall clause 170 as amended carry? Yes. Okay, shall clauses 171 through to and including clause 180 carry? Yes. Okay. Thank you. Moving right along. Clause 181 takes us to G53. Shall G53 carry? Yes. Carry. Shall clause 181 as amended carry? Yes. Carried. Okay, now, hold on. Takes us to new clause 181.1 and CPC 32. Mr. Gill.
Thank you, Chair. And this amendment is by my colleague, Mr. Lawton, and I would like to move that. This amendment would streamline reporting requirements. It is a change that will remove redundancy and make it easier to work with our provincial and international allies to end child abuse.
Thank you, Mr. Gill. Okay, shall CPC 32 carry?
Yes.
Mr. Clerk?
Yes. On CPC 32, Mr. Chair, Madame Latenzio? No. Monsieur Housewater?
No.
Madame Gladu?
No.
Monsieur Guilbeault? Madame Khalid?
No.
Monsieur Saini?
No.
Mr. Brock?
Yes.
Mr. Baber?
Yes.
Mr. Manto?
Yes.
Mr. Gill?
Yes.
Monsieur Fortin?
No.
Defeated. Okay, clause 182 takes us to G54. Moved?
Moved.
Shall G54 carry?
Yes.
Clerk?
Yes, just a second. It's going fast. Yep, on G54, Mr. Chair, Madame Latenzio?
Yes.
Monsieur Housefather?
Oui.
Madame Gladu?
Oui.
Monsieur Guilbeault?
Oui.
Madame Khalid?
Yes.
Monsieur Saini?
Yes.
Mr. Brock?
Nay.
No. Mr. Baber?
No.
Mr. Mantle?
No.
Mr. Gill?
No.
Monsieur Fortin?
No.
Carried. Shall clause 182 as amended carry? Carried. Shall clauses 183 through to and including 189 carry? Thank you. Clause 190 takes us to G55. Ms. Gladu?
Deemed it
Moved, okay. Shall G55 carry?
Oui.
Yes, okay, thank you. Shall clause 190 as amended carry? Carried. Shall clauses 191 through to and including 194 carry? Carried. Clause 195 takes us to CPC 33. Mr. Gill?
Thank you, Chair. And once again, I would like to thank my colleague, Mr. Lawton, for writing this amendment, and I would be very happy to move that. This amendment is similar to CPC 29 in that it promotes the protection of victims. This amendment will require that victims are notified of the offender's eligibility dates and review dates for parole and unescorted temporary absences. Dates on which the offender is to be released on unescorted temporary absence, parole, or statutory release. Hearing dates for parole reviews and the condition, locations, and duration of unescorted temporary absence, parole, or statutory release. If we all truly care about victims' rights, Mr. Chair, then it is common sense that they should be informed about any potential changes in their abuser's sentence. I urge all members to support victims and support this amendment. Thank you.
Thank you. Anyone else? Shall CPC 33 carry?
Yes.
Mr. Clerk?
Yes. Thank you, Mr. Chair. On CPC 33, Madame Latenzio?
No.
Monsieur Housefather?
No.
Madame Gladu?
No.
Monsieur Guilbeault?
No.
Madame Khalid?
No.
Monsieur Saini?
No.
Mr. Brock?
Yes.
Mr. Baber?
Yes.
Mr. Mantle?
Yes.
Mr. Gill?
Yes.
Monsieur Fortin?
Oui.
Okay, shall clause 195 carry? Carried. Shall clauses 196 through to, including clause 201 carry? Thank you. Clause 202 takes us to G56. Shall G56 carry? Yes. Carried. Shall clause 202 as amended carry? Shall clauses 203, 204, and 205 carry? Yes. Okay, which takes us to clause 206, which is NDP 33, which I have reviewed and am deeming out of scope. Sorry, that was NDP 33, yes, okay, which takes, yeah, shall clause 206 carry? Yes. Okay, get that section up. Okay, so let's just catch our breath for a second here. That was, yeah, why don't we suspend for just a couple minutes again?
Of members around the table, because we've had some new additions ever since this morning. Can you
Right.
just remind the committee members which two that we've put to the end, we've deferred to the end of the meeting?
I was
so that
suspending
we're
so I
clear.
could figure that out myself, Ms. Latendra.
Good idea.
Yeah.
Suspend and then tell us when it's back.
Yeah, we'll suspend and we'll come back.
Okay.
Please don't ruin.
Thank you. No, no.
Deferred. I'll start with Clause 37, which was CPC 21. We deferred that until the end. I've looked at this again and looked at my notes again, and it appears that I have caused some confusion. This amendment is indeed out of scope. I looked at I recognized this once the submissions had started, and I didn't want to interrupt out of fairness. I've looked at the rules of practice and procedure. I am within my rights, and it's within the rules that I can rule it out of scope prior to it being voted on, so that is what I'm doing with respect to CPC 21.
Clarification here. You ruled it was in order. I expressed surprise that the chair did that in light of your previous rulings. You gave me the floor. This committee heard robust submissions from myself, from Mr. Baber, I believe Mr. Gill, several Liberal members. In the spirit of collaboration, which this Prime Minister is quite proud of saying that his new Liberal government, notwithstanding the manufactured majority, is prepared to work with opposition. I was optimistic. In fact, if you recall, Chair, I was thanking my Liberal colleagues for even considering the prospect of supporting this. I had discussions with the parliamentary secretary. We agreed to afford the Liberal Party as much time as they needed to contemplate their position. Literally 10 minutes ago, I asked the parliamentary secretary if she's landed on a position. She said no, wait and see. And now you drop this bomb on our lap, Chair, reversing your earlier decision to rule it within scope. So I'm extremely, extremely disappointed.
And look, I understand the source of your disappointment, and I will apologize again for any confusion that was caused on my part. Notwithstanding that, the rules are quite clear that I have the authority to rule it out of scope prior to the vote, and that is what I am doing. I apologize again for the confusion, but that's my ruling. And Mr. Brock, I mean, you said it again yourself now. You did express surprise when I did allow it to proceed earlier. So I apologize, but that's the ruling. The option is to challenge the ruling, or we can move on. Okay.
Thank you, Mr. Chair. On the motion, shall the chair's ruling be sustained on CPC 21?
Show some courage.
Madame Natanzio.
Yes.
Mr. Housefather? Madame Gladu, pardon?
Yeah.
Monsieur Guilbeault? Madame Kelly?
Wow.
Mr. Saini?
Yeah. Bunch of hypocrites.
Mr. Brock?
That's not very nice.
Well, it is. I'm calling it out for what it is.
All right, let's.
There's no transparency. There's no collaboration here.
Mr. Brock, we're voting here. I understand there's frustration around the table. It's unnecessary to be casting aspersions and other. It's not
increase in
necessary.
extortion in this country.
Necessary. We're not debating this anymore, Mr. Brock. Apologies. We're voting. It's a yes or no vote.
No.
Mr. Baber?
I'm against the chair overruling themselves.
It's a yes.
No.
I didn't overrule myself, Mr. Babbert. Mr. Mantle?
Okay.
Mr. Gill?
No.
Mr. Fortin?
Oui.
Okay, sustained. Okay, so that takes us to
Clause 37.
Clause 37.
Yeah, that was where
No,
CPC.
I thought it was clause 36. Clause. Oh, sorry. Yeah. Right. Okay. Okay. So shall clause 37 carry? Carried. Okay. So now we move on to.
CPC 23
Yeah.
and the sub-amendment of Mr. Brock.
Now we're back to CPC 23, Mr. Brock, which I believe was your sub-amendment. Mr. Gill?
I believe first we're disposing of Mr. Brock's sub-amendment, and then a further sub-amendment if there is one.
That's what I just said.
Oh, I'm sorry. Sorry. Mr. Brock's sub-amendment, yeah?
Okay, we're going to vote on Mr. Brock's sub-amendment?
I guess.
Okay.
On
Perhaps we can clarify for the members who weren't here earlier. Is that
My understanding, I thought that Mr. Brock had withdrawn his sub-amendment, or what, did he withdraw CPC 24?
he withdrew CPC
Okay, all right,
24?
thank you.
Okay.
On the sub-amendment of Mr. Brock to CPC 23, Madame Latenzio?
No.
Monsieur Hausfader?
No.
Madame Gladu?
No.
Monsieur Guilbeault?
No.
Madame Khalid?
No.
Mr. Saini?
No.
Mr. Brock?
Yes.
Mr. Baber?
Yes.
Mr. Manto?
Yes.
Mr. Gill?
Yes.
Monsieur Fortin?
Oui.
6-5.
Okay.
Defeated.
Defeated. So now, Mr. Barber, there's another amendment, is that what you're telling me?
There's another sub-amendment.
Another sub-amendment?
No, not yours.
Mr. Mantle?
Yeah, thank you, Mr. Chair. I'd like to move a sub-amendment to CPC 23 to strike out everything after 1.1 in that sub-amendment and replace it with the following. In determining the constitutionality of any mandatory minimum penalties, the court shall not consider reasonable hypotheticals.
Okay, do you have this in writing?
We will have it in writing momentarily. Could we suspend briefly?
Yes. Suspended. wait, how many people do we have? Where'd Stephen go?
Replaced. He's replaced.
Okay, well, we're missing somebody. Tatiana's online, okay, good. All right. Okay, so everybody's got the sub-amendment received by email.
Yes.
Yes.
Any comments on the sub-amendment before we vote? Mr. Baber? Mr. Mail?
Sorry, can we have a copy of the amendment?
It's in your email.
Thank you.
Do you want me to speak first?
I'll go, no, if I may. So I'd like to speak to my friend Mr. Menzel's amendment. The amendment basically states the reason for the bill. The whole reason for the bill is to not consider reasonable hypotheticals, to deviate from this practice where courts do not look at the facts before them, but they consider a hypothetical scenario, and on the basis of that hypothetical scenario, strike down the mandatory minimum penalty is unconstitutional. Now, we've had some exchanges with the officials who believe that the safety valve will now potentially end this practice. But I'm not sure that the practice will end, and there's absolutely no reason for us not to be certain. I'd like to question the officials on this. If we can please look at page 71 of the bill, section 718.4 sub 1. What the new section says is that when you're imposing a sentence for an offense that has a minimum punishment, a court shall consider a short term of imprisonment than the specified term if in the circumstances the minimum punishment would amount to cruel and unusual punishment for that offender. In other words, Ms. Burt or Mr. Taylor, what I understand the bill to do is to basically say that when looking at that individual offender, a court may consider a lower sentence than the MMP if the court deems it to be cruel and unusual for that offender. Am I correct?
Yeah, you're correct. This is a sentencing provision. This is a sentencing provision, and your understanding of how it operates is correct.
Thank you. However, nothing in the section precludes the court from looking into the constitutionality of the MMP. In other words, before you get to the sentencing stage, nothing prevents the mounting of an argument that the mandatory minimum penalty is in and of itself unconstitutional because it's cruel and unusual, correct?
Correct. I mean, there would be a
There you go.
separate process for a constitutional challenge, and if I can just quickly.
If I may, Mr. Taylor, this is the most important moment of everything that happened on this bill. The bill was brought in order to eliminate the practice of reasonable hypotheticals. And we just heard from Mr. Taylor that even though you're supposed to avail yourself of the safety valve as it pertains to the individual offender, nothing still precludes the court from looking at the constitutionality of an MMP. So you can still come back and say this MMP is cruel and unusual on the basis of this reasonable hypothetical, and therefore the entire clause would be struck down, therefore defeating the entire purpose of this bill. This amendment is very clear-cut. It says a court shall not consider a reasonable hypothetical. That's why we're here. Why not pass this basic, very clean language? This is tantamount to, we're performing surgery on a patient, we're removing the cancer, but we're not going to stitch up the patient after we're done with the surgery. If the Liberals are really serious about preserving mandatory minimum penalties while avoiding cruel and unusual scenarios for individual offenders, they got it done. But they have neglected to impose a mechanism where reasonable hypotheticals would still not be considered, and this amendment does that. So let's think about this for a little more. I'm glad that now everybody understands the legal landscape that I've been talking about for days. Let's actually accomplish what C-16 sets out to accomplish. Thank you.
Mr. Mansell, did you want to go?
Aptly said.
Okay, Mr. Brock, over to you.
We should all strive for a certain standard as parliamentarians. And that standard is statutory clarity. And I couldn't agree more with Mr. Baber. The whole spirit of this section of Bill C-16 is to avoid the rampant misuse of reasonable hypotheticals as a means to strike down mandatory minimum penalties. And I believe that justice officials confirmed this throughout 2 days of clause-by-clause consideration, and maybe simply addressed this recently with Mr. Baber. There is nothing specifically directing judges in Bill C-16 to preclude them from looking at reasonable hypotheticals. There's no language, no direction. Is that correct? Is that my interpretation of this bill?
Thank you for the question, Mr. Brock, and through you, Mr. Chair. When a court, just to be really crystal clear, the bill's proposed changes in this clause are sentencing amendments that relate to a sentencing outcome for a specific offender, and they require the court to look at the particular circumstances of that offender and whether the mandatory minimum penalty that would apply in those cases would be cruel and unusual with respect to that offender. Mr. Baber talked about that. A constitutional challenge to a mandatory minimum penalty that were to be launched separately from this provision, which, as I said, is a sentencing provision, would follow the same approach that exists in jurisprudence today. So the court would look at the particular circumstances of the specific offender before the court, and then they would go on to the reasonable hypothetical analysis. In one of my comments last week, what I emphasized, though, is that what we expect would happen in those circumstances is when analyzing the particular circumstances of a reasonably foreseeable case, a reasonable hypothetical, the court would have resort to the fact that in that reasonably foreseeable case, a court would be able to depart from the MMP if in the circumstances of that offender, it would amount to cruel and unusual. So although they can, as we understand it, undertake in a constitutional analysis, an analysis of a reasonable hypothetical case, the outcome would still be the same because the court would still, as part of the consideration, be able to avail of itself of the escape clause.
Thank you for that. I don't think it completely answers my question or my concerns, and this is a concern that every member of this committee should have. I wholeheartedly feel that without direction within the statute itself, within this bill itself, to look at factors to consider when you're going to deviate, without seeing specific language that does not look at or consider reasonable hypotheticals, in my view, we're actually going to be increasing the level of litigation because I can't foresee any defense counsel worthy of his or her practice not taking a further constitutional challenge of all those offenses that have been resurrected by Bill C-16 that had been previously ruled to be contrary to Section 12. Why wouldn't a competent defense lawyer bring yet another constitutional challenge? So all I've been hearing all day long today and part of last Wednesday is to avoid the whole use of increased litigation. So all the more reason for my liberal colleagues to look at the utility and the significance of Mr. Baber's amendment, where we can take a look at closing a loophole that currently exists in Bill C-16 that has the potential of opening up litigation floodgates. That's all I'm asking for consideration from my colleagues opposite.
Thank you. Mr. Mantle?
Thank you, Mr. Chair, I just want to clarify my understanding with officials here, and forgive me for being coming a little bit to this new. But if I understand my colleague's argument, is that the purpose of Bill C-16 in part was to address the issue of reasonable hypotheticals, which led to what Parliament has considered, or members of Parliament have considered to be results incongruous with our view of the severity of the crime and the sentence that should have been imposed. And so part of the goal of this is to remove the potential use of reasonable hypotheticals to get to those incongruous results. If I'm understanding the operative provision of Bill C-16, it doesn't close that ability, because a litigant could still raise the constitutionality of the underlying minimum penalty. Is that correct?
Yeah, conceptually it is correct that an individual could launch a charter challenge to an MMP as it being contrary to Section 12, constituting cruel and unusual punishment.
In the normal process, would those arguments take place before we would even get to the sentencing provision? Like you would dispose of that argument first before getting to this one?
Yeah, I think they would.
So if a litigant was successful in those arguments, this operative provision of Bill C-16 would be moot?
So I think the analysis there, and it's a good question, and thank you for it, would follow along the lines of what I answered to Mr. Brock, in that in considering the constitutional arguments in respect of a mandatory minimum penalty, the court would follow the two-step process. So in the first instance, they would consider the specific impacts on the individual before the court, that particular accused or offender, and would it constitute cruel and unusual punishment vis-a-vis them. They would be able to avail themselves of the fact that this clause exists if C-16 were to pass, to come to the conclusion that but for this clause, the result vis-a-vis the specific offender before the court would constitute cruel and unusual punishment. But because of the clause, were it enacted, the court would need not come to that conclusion, because it would have the ability to depart in relation to the specific offender. If in respect of the specific offender, the MMP wasn't cruel and unusual, they wouldn't have to consider proposed 718.4, because it wouldn't amount to cruel and unusual punishment in those specific cases. They would still be required to move to the second stage of the constitutional analysis, the reasonable hypothetical. Would it be grossly disproportionate for a reasonable case that is not far-fetched, as the court has said? And in those circumstances, as I said to Mr. Brock, our understanding would be that, again, the court would be able to take into account that even in respect of that reasonably foreseeable situation, the court would be able to invoke 718.4 for that reasonably foreseeable offender and allow them to impose a sentence of less than the mandatory minimum penalty of imprisonment. So whether it's cruel and unusual with respect to the specific offender, or whether it's cruel and unusual with respect to the hypothetical offender, 718.4 would provide an alternative approach for the courts to impose less than the MMP.
Strike the entire thing down.
Yeah. Thank you for outlining that two-step process. I didn't practice criminal law, so I'm not as familiar with the procedure, but could that's one option that a court could take. Could the court not also just strike the entire provision before you get to that?
The MMP itself, or 718.4?
The MMP.
They would have to undertake that analysis, is my understanding.
They could.
Are they
said that they could strike it down.
Yeah. Okay. Thank you.
You're done, Mr. Middle? Yeah, okay, thank you.
Mr. Taylor.
Mr. Babber, you would
Yeah,
like to speak?
Mr. Taylor just contradicted himself. In the previous answer to my colleague, Mr. Mantle, you said that, yes, the process would be that you first might challenge the constitutionality of the entire MMP, in which case the court would be able to look at a reasonable hypothetical before it gets to the sentence for the individual accused, correct? They might choose, one second, they might choose an off-ramp that's available to them in 718.4, but they may not, Mr. Taylor. Is that correct?
So the constitutional challenge would be open to an accused to launch, as I've said.
And that may involve the consideration of a reasonable hypothetical.
And in consideration of that reasonable hypothetical, were this bill to pass, the courts would be required to consider the operation of 718.4 with respect to that offender in the reasonable hypothetical circumstances. So vis-a-vis that reasonably foreseeable offender, this sentencing tool would be available to the court. So in respect of that reasonably hypothetical offender, there would never be a result where the court could not impose less than the MMP if, in respect of that case, it would constitute cruel and unusual punishment.
But the language says when imposing a sentence for an offense, the court, you see that, and that's what we've arrived at here, is that we have decided to focus on the individual offender, which is why, to begin with, we had this bad drafting that we sought to amend by clarifying the whole thing. And Mr. Taylor, I take exception to your suggestion that, yes, the court may avail itself of the off-ramp, but the court is not required to go that route. It would still be open to the court to say that this mandatory minimum penalty should be struck down entirely without getting to the individual offender. You are not imposing a safety valve on a reasonable hypothetical. You are imposing a safety valve on the accused before you. Now, let me ask you, Mr. Taylor. I don't know if you're allowed to recommend or provide legal advice, but we now have an amendment before the committee. For greater certainty, would it not be, if the intent of this bill was to prevent judges from looking at reasonable hypotheticals in consideration of whether an MMP is constitutional or not, would it not be prudent for us to instruct the court not to look at reasonable hypotheticals when considering the constitutionality of a specific MMP? And that's at an issue at the outset when there's a charter launch on the MMP, regardless of the accused. Would that not be prudent for us?
So if I understand I don't have the exact wording in front of me in terms of the motion, but I think I have the general sense of it. My understanding of the sub-amendment and the motion more generally is that it would, in effect, it is not, as I understand it, a protection against constitutional challenges, because it is an amendment to 718.4 itself and 718.4 subsection 1. And 718.41 is a sentencing provision that allows a judge, in respect of a specific offender, to depart from the imposition of an MMP if it would be cruel and unusual with respect to that offender. 1.1, in my understanding, would not preclude the ability of an individual accused to launch constitutional challenge to an MMP under Section 12. My understanding of CPC 23 is that it is very much constrained to the architecture that is proposed in C16 around the safety valve and the ability to depart from the MMP in a particular case.
1.1 does not in any way, in my view respectfully, abridge the intent of 718.4 sub 1. It's a clarification, which is why it follows. We're not changing the safety valve. We're not changing how the court would approach an individual accused. we're adding a clarification on top to say that we stay with the individual accused and still provide them the off-ramp, still avail yourself of the safety valve. But we will not consider reasonable. You can challenge the constitutionality of an MMP on a bunch of grounds. But CPC 23, our amendment only talks about this specific ground, which is to say you cannot challenge the MMP as a whole using a reasonable hypothetical. That's what it says. Why not go the extra step and be prudent, be cautious, so we're not back here in 3 to 5 years from now looking at another Centerville decision? Please add yourself to the list. Add yourself to the list.
Yeah.
Are you on the list? Thank you. Yeah. Thank you.
You done, Mr. Bauer?
Yeah, yeah.
Okay, I'm going to suspend for just a couple minutes. We've got a speaking list going, so suspend for 5 minutes. left off with, we were just about to hear from Mr. Brock. And then we've got, okay, hold on. Yep, hold on. I've got Mr. Lawton, so I've got Mr. Saini, and I've got Mr. Lawton, and I've got, you know what? We'll go you first, and then, yeah, Mr. Mantle, and then Mr. Gill. Did you have your hand up? Oh. Okay, Mr. Brock, you have the floor.
So, Mr. Chair, thank you for recognizing me. You know, I hearken back to some earlier comments that I've made and comments I've made in other bills. The whole purpose of parliamentary standing committees is to examine either policy or legislation from government, hearing from witnesses, cross-examining those witnesses, and then ultimately getting to clause-by-clause consideration, where we put forth reasonable, intelligent amendments from all parties represented here at committee. And the whole purpose behind that, obviously, is, and I think Bill C-16 is a classic example of the importance of committees, the importance of studying legislation, leaving aside all the talking points and the positioning and the jockeying of positions during the second reading, potentially third reading. But you get to actual, real, substantive work at committees. And I'm sure all of us at this table have been to numerous riding events. And we have to correct, usually every single time it comes up. So what is it actually you do as a member of Parliament? All I see is people on television slapping their hands on their desk and screaming at each other. You look like a bunch of grade school children. And for a lot of Canadians, that's their view of parliamentarians, what they actually see on television every day from 2 to roughly 3:15. And I take every opportunity to correct that falsehood. I say it's called question period, and the opposition will ask pointed, direct questions of the Prime Minister, his ministers, his parliamentary secretaries, his backbench, but not once, absolutely not once, do you get a responsive answer to a question. Instead, it becomes a theatrical performance by the government triumphing their old, tired talking points about being a new government, and notwithstanding that they've got this manufactured majority because of floor crossers, one of which is currently in our Justice Committee as I speak.
No justice there.
No. So they talk about, notwithstanding the majority, we want to be collaborative. We want to work together. And what have we seen in the last 2 weeks? We've seen 4 examples of opposition MPs trying to open up that tightly guarded window and curtains called transparency and accountability, and this new liberal government filled with old, tired MPs. Shut it down. Shut it down. Because they don't want to answer to Canadians. They do not and have never, since I have been a proud member of His Majesty's loyal opposition, I have never seen this tired old Liberal government ever agree to shine light, to cooperate on issues pertaining to corruption, to government spending.
Ms. Gladue?
Yes, Chair, I'm really not sure what the relevancy of doing personal attacks and pontificating on motives is got anything to do with the amendment of which we are speaking right now. So I would ask you to call the member back to relevancy. Thank you.
I think that's Mr. Brock, just bear with me for a second. I think that's a fair point of order. I mean, we do need to find some
I'm going to get there.
Tangential connection sooner rather than later.
I'm going to get there. And I know, Chair, you and I have bantered back and forth, and you asking me, well, you know what, point out that particular judge. When I comment onto you that relevancy often has a subjective element to it, and you always,
and I always point
call
out
me
that
out on that.
Yes.
Okay.
Otherwise, there'd be no such thing as relevance other than in the eye of the beholder, yeah.
But I find it rather rich that Ms. Gladue would now be raising that as a point of order, when just a few months ago, she'd be in this chair right now,
Mr. Brock,
doing the very same thing that I'm doing.
Mr. Brock, you and I have also discussed, as have other members of this committee, that we do have a cordial relationship around this table, and casting aspersions and this type of conduct doesn't help maintain that. So if we can focus on the issues, I would be grateful.
So I'll get to relevancy. So again, I talked about the purpose of committees. I talked about what we as opposition members have tried to do over the last 2 weeks. And the Liberal government plays games and just shuts down any attempt to get to the truth. So here is a wonderful opportunity to really provide some teeth and some backbone to Mark Carney's assertion that this is a new Liberal government that is willing to collaborate, willing to listen to good ideas, because the whole purpose of committee work is to improve on legislation, proposed legislation. And I raised this, Mr. Chair, to you, I believe last Wednesday, when I commented on
Point of
literally
order,
the
Mr. Chair.
literally the.
Ms. Khaled has a point of order.
Thank you again, Chair. I really think relevance is important. We've had a really wonderful discussion throughout the day. We have collaborated. I would just really hope that we can, like the elephant has passed the room, the tail is left. Let's finish it off.
Thanks. We are
See that elephant, and
we are
I'm
pushing
within
on
touching.
8 hours. We are pushing on 8 hours, Ms. Khaled. Mr. Mantle, you don't have the floor. You don't have the floor, Mr. Mantle.
Fisheries Committee for hours.
If you would
Okay, I'll wait
show
till
some
my
respect to the process of the chair, I'd be grateful. Thank you.
I'm trying to explain relevancy, and Ms. Khaled has enjoys the opportunity of disrupting my train of thought, but nevertheless,
Point of order.
It failed again.
Once again, casting aspersions on members of this committee is unhelpful, and I think the members opposite are just obstructing, trying to waste time instead of trying to get to the finishing of this very important bill that is critical for women in this country.
The
Thank
pot calling the kettle black.
Yeah, okay. You know what, Mr. Brock? I'm pretty flexible and pretty generous. I think people will agree in terms of letting us stray afield from the relevance of particular topics, but
I'm getting to it.
I know, but
Mr.
let's. I'm saying this to everybody in the room. Making comments about other members, Mr. Brock, or insinuating things about other people around this table or not around this table, is not only unproductive; it's unparliamentary. So I'm asking again, please, everybody, refrain from doing that. Stick to the discussion at hand, and we can get out of here at a reasonable time. Thank you.
So I commented on this point last Wednesday, that when I took a look at the number of amendments, I noted that the Liberals actually almost doubled the number of amendments from the Conservative Party. And I believe it was the Parliamentary Secretary, Ms. Latanzio, that pointed out correctly that they weren't necessarily substantive. They were editing issues or translation issues, there have been some substantive amendments, and there's been a high degree of collaboration throughout the last 2 days in clause-by-clause consideration, leaving aside what transpired about an hour ago with the chair reversing himself. But I'm not going to comment any further on that.
Okay, I'm going to interject now. I did not reverse myself, Mr. Brock, and to state that is not only inaccurate, it's wrong. I was entitled to make the ruling that I did. If you want to make political hay out of this thing, you're free to do so outside this room, but you're not going to do it here.
Well, you changed your mind.
I did not, Mr. Brock. I made a ruling. I allowed you to proceed earlier, and then I made a ruling that was out of scope. It's the end of the discussion.
Right. Well, you and I will agree to disagree on that particular issue. I'll leave it at that. But the whole point here is to improve on legislation. And what this committee has heard from Conservative members today and last Wednesday were reasonable amendments to reflect on improving legislation. I strive, and I think we all should be striving, for clarity when we're drafting legislation, when we have legislation that passes. Where you don't have clarity, that opens up litigation. And I've heard nothing but intervention after intervention from my Liberal colleagues about avoiding the increase in litigation, which brings me again to highlight the importance of Mr. Baber's amendment to ensure that there is clarity, to ensure that this respects the spirit of this section of Bill C-16, to forever close out that concept during the sentencing aspect of Bill C-16, to close the concept of the use of reasonable hypotheticals. And I believe what I've heard so far from my Liberal colleagues is, in their interventions, is support for that. But I suspect that once this particular amendment reaches its conclusion in terms of interventions, I'm getting the sense that the Liberal Party is not prepared to vote in favor of this amendment. So in my view, they are voting contrary to the stated intentions that they have already telegraphed throughout the day and this past Wednesday, and in my view, runs contrary to our stated purpose of improving legislation with clarity. Thank you, Mr. Chair.
Meeting adjourned.
Good.
Thank you.